This case before us deals with the asymmetric federal model of governance in India involving the contest of power between a union territory and the union government. The issue is who would have control over the services in the National Capital Territory of Delhi, the government of the NCTD, or the Lieutenant Governor acting on behalf of the union government. The question arose subsequent to a notification dated 21 May 2015 issued by the Union Ministry of Home Affairs. The limited issue for the consideration of this constitution bench only relates to the scope of legislative and executive powers of the center and NCTD with respect to the term services. That is to say, whether the NCTD or the union government has legislative and executive control over services. Then we deal with the constitution bench of 2018 and say, we are unable to agree with the view of Justice Bhushan in the 2019 split verdict. As indicated previously, the majority decision in the 2018 Constitution Bench judgment rendered a broad interpretation of Article 239 AA3A to provide NCTD with vast executive and co-extensive legislative powers except in the excluded subjects. A combined reading of the majority opinion and the concurring opinions of Justice Chandrachud and Justice Bhushan indicates that the phrase insofar as any such matter is applicable to union territories does not restrict the legislative powers of NCTD. While the 2018 Constitution Bench judgment provides sufficient clarity on the interpretation of the phrase insofar as any such matter is applicable to union territories, we find it necessary to deal with the arguments made by the Union of India that the phrase must be read in a restricted manner to limit the legislative power of NCTD on certain subjects in addition to already excluded subjects in List 2. Article 239 AA3A confers legislative power to the NCTD. However, it does not confer legislative power to NCTD over all entries in List 2. Article 239 AA3 provides multiple safeguards to ensure that the interest of the Union of India is preserved. First, subclause A of clause 3 removes 3 entries in List 2 from the legislative domain of NCTD. It provides that NCTD shall not have the power to enact laws on matters with respect to entries 1, 2, and 18 of the state list, and entries 64, 65, and 66 of that list insofar as they relate to the said entries 1, 2, and 18. Second, subclause B of clause 3 clarifies that Parliament has the power to legislate on any matter for a union territory, including on subjects with respect to which NCTD has legislative power under Article 239 AA3A. In other words, Parliament has a plenary power to legislate on a subject in any of the 3 lists of the 7th schedule for NCTD. Third, it provides that where there is a repugnancy between a law enacted by the Legislative Assembly of NCTD and a law enacted by Parliament, the latter will prevail. The law enacted by the Legislative Assembly shall, to the extent of the repugnancy, be void. Unlike Article 254, which provides for the overriding power of Parliament only on subjects in the concurrent list, Parliament has overriding power in relation to the NCTD over subjects in both List 2 and List 3. Fourth, the second proviso to Article 239 AAC provides that Parliament may enact at any time any law with respect to the same matter by including a law adding to, amending, varying, or repealing the law so made by the Legislative Assembly. Fifth, under 239 AA7A, Parliament may by law make provisions for giving effect to or supplementing the provisions in the foregoing clauses of 239 AA, and for all matters incidental and consequential thereto. The article stipulates that such law shall not be deemed to be an amendment of the Constitution for the purposes of Article 368, which deals with the power and procedure to amend the Constitution. Thus, Article 239 AA3 balances between the interests of NCTD and the Union of India. Article 239 AA expressly excludes entries 1, 2, and 18 of List 2 from the ambit of the legislative competence of the Legislative Assembly. 239AA also stipulates that the legislative power of NCTD is excluded with respect to entries 64, 65, and 66 of List 2, insofar as they relate to entries 1, 2, and 18. Entry 1 deals with public order, entry 2 deals with police, and entry 18 deals with land. When we explain the entries, thus the exclusion of entries 64, 65, and 66 to the extent that it relates to entries 1, 2, and 18 from the legislative competence of NCTD indicates that the governance structure envisaged in Article 239AA for NCTD was only to exclude specific entries from its legislative competence. To read the phrase insofar as such matter is applicable to the Union territories as introducing an implied exclusion of the legislative powers of NCTD with respect to certain other entries would be contrary to the plain meaning of the provision. Article 239AA establishes the Legislative Assembly for NCTD. The seats in the Legislative Assembly are filled by a direct election from the constituencies of NCTD. The Legislative Assembly of NCTD embodies the constitutional principle of a representative democracy similar to the Legislative Assembly of the state. The members of the Legislative Assembly of the NCTD are selected by the electorate of Delhi to represent their interests. Article 239AA must be interpreted to further the principle of representative democracy. To interpret the phrase insofar as any such matter is applicable to Union territories in a restrictive manner would limit the legislative power of the elected members of the Assembly. The members of the Legislative Assembly have been chosen by the electorate to act in their stead. Thus, the legislative competence of NCTD must be interpreted to give full impetus to the will of the electorate. Then page 53. The principles of democracy and federalism are essential features of our constitution and form a part of the basic structure. Federalism in a multicultural, multi-religious, multi-ethnic, and multilinguistic country like India ensures the representation of diverse interests. It is a means to reconcile the desire of commonality along with the desire for autonomy and accommodate diverse needs in a pluralistic society. Recognizing regional aspirations strengthens the unity of the country and embodies the spirit of democracy. Thus, in any federal constitution, at a minimum, there is a dual polity. That is, two sets of government operate, one at the level of the national government and the second at the level of the regional federal units. These dual sets of government, elected by we the people in two separate electoral processes, is a dual manifestation of the public will. The priorities of these two sets of government, which manifest in a federal system, are not just bound to be different, but are intended to be different. While NCTD is not a full-fledged state, its legislative assembly is constitutionally entrusted with the power to legislate upon the subjects in the state and list and concurrent lists. It is not a state under the first schedule to the Constitution, yet it is conferred with power to legislate upon subjects in List 2 and 3 to give effect to the aspirations of the people of NCTD. It has a democratically elected government which is accountable to the people of NCTD. Under the constitutional scheme, NCTD was given legislative power which, though limited in many aspects, is similar to states. In that sense, with the addition of Article 239AA, the Constitution created a federal model with the Union of India at the center and the NCTD at the regional level. This is the asymmetric federal model adopted for NCTD. While NCTD remains a union territory, the unique constitutional status conferred upon it makes it a federal entity for the purpose of understanding the relationship between the Union and the NCTD. A combined reading of Articles 73 and 162 of the Constitution indicates that the Union has exclusive executive power over entries in List 1. The states have exclusive executive power over entries in List 2. With respect to List 3, that is a concurrent list, the Union shall have executive power only if provided by the Constitution or by a law of Parliament. The states shall have executive power over the entries in List 3. However, if a central legislation or a provision of the Constitution confers executive power to the Union with respect to a List 3 subject, then the executive power of the state shall be subject to such law or provision. The executive power of the Union in a state over matters on which both states and the Union of India can legislate, that is the concurrent list, is limited to ensure that the governance of the states is not taken over by the Union. This would completely abrogate the federal system of governance and the principle of representative democracy. It is with this objective in mind that the members of the Constituent Assembly thought it fit to limit the executive power of the Union in a state over matters on which the state legislature also has legislative competence. The principle in Articles 73 and 162 would equally apply to the scope of executive power over matters which are within the legislative competence of both the Union and the GNCTD. This is because the objective of the provisions is to limit the executive power of the Union in the territorial limits where there is an elected government of a federal unit. Both Parliament and the legislature of NCTD have legislative competence over List 2 and List 3. For the purposes of NCTD, both List 2 and List 3 are concurrent lists. Thus, the delimitation of executive power between Parliament and the government of NCTD with respect to entries in List 2 and List 3 are guided by these principles. Both Parliament and the legislature of the NCTD have the power to enact laws with respect to List 2, subject to the caveat that entries 1, 2, and 18, and entries 64, 65, and 66, inasmuch as they relate to entries 1, 2, and 18, are carved out of the domain of the Legislative Assembly of GNCTD and List 3. The executive power of NCTD shall extend to all entries in List 2 and List 3, other than those entries which are expressly excluded in Article 239 AA3. Such power shall be subject to the executive power of the Union through the Lieutenant Governor only when the Union has been granted such power by the Constitution or a law of Parliament. Therefore, the executive power of NCTD in the absence of a law by Parliament shall extend to all subjects on which it has power to legislate. It was held Then we cover Rule 46 of the rules, and we say, the rule provides that the Lieutenant Governor shall exercise such powers and functions with respect to persons serving in the administration of NCTD as may be entrusted to him under the provisions of the rules and orders regulating the conditions of service of such persons or by any other order of the President. The term administration in this rule must be considered in the context of Article 239 AA3 and Section 41 of the GNCTD Act. The executive administration by the Lieutenant Governor, in his discretion, can only extend to matters which fall outside the purview of the powers conferred on the Legislative Assembly, but it extends to powers or functions entrusted or delegated to him by the President, or in which he is required by or under law to act in his discretion or to exercise any judicial or quasi-judicial functions. The term administration cannot be understood as the entire administration of GNCTD. Otherwise, the purpose of giving powers to a constitutionally recognized and democratically elected government would be diluted. In a democratic form of government, the real power of administration must reside in the elected arm of the state, subject to the confines of the Constitution. A constitutionally entrenched and democratically elected government needs to have control over its administration. The administration comprises of several public officers who are posted in the services of a particular government, irrespective of whether or not that government was involved in their recruitment. For instance, an officer recruited by a particular government may serve on deputation with another government. If a democratically elected government is not provided with the power to control the officers posted within its domain, then the principle underlying the triple chain of collective responsibility would become redundant. That is to say, if the government is not able to control and hold to account the officers posted in its service, then its responsibility towards the legislature as well as the public is diluted. The principle of collective responsibility extends to the responsibility of officers who in turn report to the ministers. If the officers stop reporting to the ministers or do not abide by their directions, the entire principle of collective responsibilities is affected. A democratically elected government can perform only when there is an awareness on the part of officers of the consequences which may ensue if they do not perform. If the officers feel that they are insulated from the control of the elected government which they are serving, then they become unaccountable or may not show commitment towards their performance. We have already held that the relationship between the Union and the NCTD resembles an asymmetric federal model, where the latter exercises its legislative and executive control in specified areas of the state list and concurrent list. Article 239 AA, which conferred a special status to NCTD and constitutionally entrenched a representative form of government was incorporated in the Constitution in the spirit of federalism, with the aim that the residents of the capital city must have a voice in how they are to be governed. It is the responsibility of the government of the NCTD to give expression to the will of the people of Delhi who elected it. Therefore, the ideal conclusion would be that GNCTD ought to have control over services subject to exclusion of subjects which are out of its legislative domain. If services are excluded from its legislative and executive domain, the ministers and executives and the executive, who are charged with formulating policies in the territory of NCTD, would be excluded from controlling the civil service officers who implement such executive decisions. The legislative and executive power of NCTD over entry 41 shall not extend over to services related to public order, police, and land. However, legislative and executive power over services such as Indian administrative services or joint cadre services, which are relevant for the implementation of policies and the vision of NCTD in terms of day-to-day administration of the region, shall lie with the NCTD. Officers thereunder may be serving in NCTD even if they were not recruited by the NCTD. In such a scenario, it would be relevant to refer as an example to some of the rules which clearly demarcate the control of All India or joint cadre services between the Union and the states. NCTD, similar to other states, also represents the representative form of government. The involvement of the Union of India in the administration of NCTD is limited by constitutional provisions, and any further expansion would be contrary to the constitutional scheme of governance. We reiterate that in light of Article 239AA and the 2018 Constitution Bench judgment, the Lieutenant Governor is bound by the aid and advice of the Council of Ministers of NCTD in relation to matters within the legislative scope of NCTD. As we have held that NCTD has legislative power over services, excluding public order, police, and land, under entry 41 in list 2, the Lieutenant Governor shall be bound by the decisions of GNCTD on services as explained above. To clarify, any reference to Lieutenant Governor or over services, excluding services relating to public order, police, and land, in relevant rules, shall mean Lieutenant Governor acting on behalf of NCTD. Now, the conclusion. The division of administrative powers between the Union and the NCTD, as explained in this section, must be respected. In view of the discussion above, the following are our conclusions. A. There does not exist a homogeneous class of union territories with similar governance structures. B. NCTD is not similar to other union territories. By virtue of Article 239AA, NCTD is accorded a sui generis status, setting it apart from other union territories. C. The Legislative Assembly of NCTD has competence over entries in List 2 and List 3, except for the expressly excluded entries of List 2. In addition to the entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239AA 3A. D. The executive power of NCTD is coextensive with its legislative power, that is, it shall extend to all matters with respect to which it has the power to legislate. E. The Union of India has executive power only over the 3 entries in List 2, over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. G. The phrase insofar as any such matter is applicable to Union territories in Article 239AA3 cannot be read to further exclude the legislative power of NCTD over entries in the state list or concurrent list over and above those subjects which have been expressly excluded. H. With reference to the phrase subject to the provisions of this Constitution in Article 239AA3, the legislative power of NCTD is to be guided and not just limited by the broader principles and provisions of the Constitution. And I, NCTD, has legislative and executive power over services, that is entry 41 of list 2 of the 7th schedule, because 1. The definition of state under section 358 of the General Clauses Act 1897 applies to the term state in part 14 of the Constitution, Thus, Part 14 is applicable to Union territories. And 2, the exercise of rule-making power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. We have answered the issue referred to this Constitution bench by the order dated 6 May 2022. The registry shall place the papers of this appeal before the regular bench for disposal after obtaining the directions of the Chief Justice on the administrative side.
Thank you, sir. Lord, immensely grateful to your Lordship.
The petitioners have urged that the order of this court dated 27 June 2022 relied on the decision in Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions. This submission cannot be accepted. Although the parties may have addressed this court on the applicability of Nabam Rebia, the order dated 27 June 2022 did not rely on Nabam Rebia to injunct the Deputy Speaker from adjudicating the disqualification petitions on the ground that a notice of intention to move a resolution for his removal had been issued. This court instead granted an extension of time to the persons against whom disqualification petitions were filed to file their written submissions in view of the principles of natural justice. Based on the submissions which have been canvassed before us, we are of the view that the decision in Nabam Rebia merits reference to a larger bench because a substantial question of law remains to be settled. The following are our prima facie reasons for reaching this conclusion. I'll not read out all the reasons for the reference to a larger bench of Nabam Rebia, save and except to note one thing. It appears that the following aspects were not considered in Nabam Rebia. 1, whether the temporary disablement of the functions of the Speaker under the 10th schedule is prone to misuse by MLAs who anticipate that disqualification petitions will be instituted against them or by MLAs against whom disqualification petitions have already been instituted. And 2, whether a constitutional hiatus in the operation of the 10th schedule ensues because of the temporary disablement of the Speaker. To give quietus to the issue, we refer the following question and any allied issues which may arise to a larger bench, whether the issuance of a notice of intention to move a resolution for the removal of the Speaker restrains them from adjudicating disqualification petitions under the 10th schedule of the Constitution. Then we have said that pending the decision of the larger bench, as an interim measure, adoption of the following procedure may subserve the objective of the 10th schedule, the symbols order, as well as Article 179C. It may also provide some amount of clarity and certainty. And the points which we have then made for the interim is that the investing of exclusive adjudicatory jurisdiction upon the Speaker to determine the complaints under the 10th schedule will entitle the Speaker to rule upon and decide applications questioning their jurisdiction. B. 1. The Speaker is entitled to rule on applications which require them to refrain from adjudicating proceedings under the 10th schedule on the ground of initiation of a motion for the removal under Article 179C. A Speaker can examine if the application is bona fide or intended only to evade adjudication. 2. If the Speaker believes that the motion is well-founded, they may adjourn the proceedings under the 10th schedule till their decision of their removal is concluded. On the other hand, if they believe, page 61 ko correction hai, if they believe that the motion is not as per the procedure contemplated under the Constitution, read with the relevant rules, they are entitled to reject the plea and proceed with the hearing. And 3, the decision of the Speaker either to adjourn the proceedings under the 10th schedule in view of the pending proceedings under Article 179C or to proceed with the hearing will be subject to judicial review. As the decision of the Speaker relates to their jurisdiction, the bar of a quae time action as contemplated in Quixote Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rebia, strictly speaking, did not arise in the matter before us, but we thought Nabam, the controversy, should be settled by a reference to 7 judges. So I'll now go to the what we have said on the merits of this particular case. The House of the People and the legislative assemblies of states are constituted of members directly elected by the electorate. The candidate who secures the highest number of votes is returned to the assembly. The political party which reaches the halfway mark forms government. A coalition of political parties may form the government if no single political party reaches the halfway mark. Articles 75 and 164 provide that the Council of Ministers is collectively responsible to the House of People and the Legislative Assembly of the state, respectively. The legislators who are directly elected by the people have a duty to hold the executive accountable on the floor of the House. Legislative procedures serve 2 objectives. First, they enable deliberation and discussion on the floor of the House to hold the executive accountable, and such deliberation also produces better constitutional outcomes. And second, they create a system to place a check on the exercise of power by the incumbent government. Certain procedural requirements prescribed by the Constitution safeguard constitutional values. This is reflected in Article 368, which prescribes a special majority to amend certain constitutional provisions, which, according to the members of the Constituent Assembly, hold a higher constitutional and democratic value. Certain other legislative procedures further democratic processes and accountability and prevent the concentration of power in the hands of the incumbent government. Article 212 cannot be interpreted as placing all procedural infringements beyond the pale of judicial review. Such an interpretation would completely disregard the importance of legislative processes in a constitutional democracy. Now, we have dealt with the whip as to whether the whip is really a whip appointed by the legislature party or by the political party. And we say to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators can rely on the political party for the purpose of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. That a whip be appointed by the political party is crucial for the sustenance of the 10th schedule. The entire structure of the 10th schedule, which is built on political parties, would crumble if this requirement is not complied with. It would render the provisions of the 10th schedule odious and have wider ramifications for the democratic fabric of this country. Thus, the courts cannot be excluded by Article 212 from inquiring into the validity of the action of the Speaker in recognizing the whip. On 25 November 2019, a meeting with the newly elected MLAs belonging to the Shiv Sena was chaired by Mr. Uddhav Thackeray in his capacity as the Shiv Sena president, party president, Paksh Pramukh. The resolution notes that the MLAs unanimously resolved that all decisions in the meeting would be taken by Mr. Thackeray. A resolution was issued appointing Mr. Eknath Shinde as the group leader of the SSLP and Mr. Sunil Prabhu as the chief whip. On 21 June 2022, some members of the SSLP held a meeting under the chairmanship of the President of the Shiv Sena, Mr. Uddhav Thackeray. In the meeting, it was resolved to remove Mr. Shinde as the group leader of the SSLP and appoint Mr. Ajay Chaudhary. The resolution was signed by Mr. Uddhav Thackeray in his capacity as the president of the party on the official letterhead of the office of the SSLP. Then, having dealt with that, we say the Speaker was aware of the emergence of two factions in the Legislative Party on 3 July 2022 when he appointed a new whip and a new leader, because the resolution of the respondents specifically mentions that a split had occurred due to prevailing dissatisfaction in some MLAs of the Shiv Sena. Further, the fact that there were two resolutions appointing two different whips and two different leaders would no doubt have resulted in the Speaker inferring that there were two factions of the Shiv Sena. The Speaker, on taking cognizance of the resolution passed by the faction of the SSLP led by Mr. Shinde, did not attempt to identify which of the two persons who were nominated, namely Mr. Prabhu or Mr. Gogaole, were authorized by the political party. In a contentious situation such as this, the Speaker should have conducted an independent inquiry based on the rules and regulations of the political party to identify the whip authorized by the Shiv Sena political party. For the reasons detailed in the preceding paragraphs, the Speaker must only recognize the whip appointed by the political party. The decision of the Speaker recognizing Mr. Gogaole as the chief whip of the Shiv Sena is illegal because the recognition was based on the resolution of a faction of the Shiv Sena legislature party without undertaking an exercise to determine if it was the decision of the political party. Harmonizing the 10th schedule with paragraph 15 of the symbols order. This court cannot accept the solution proposed by the petitioners and lay down a constitutional sequence. To hold that the Election Commission of India is barred from adjudicating petitions under paragraph 15 of the symbols order until the final adjudication of the disqualification petitions under the 10th schedule would be in effect to indefinitely stay the proceedings before the Election Commission of India. This is because an order of the Speaker attains finality only after all avenues for appeal have been exhausted or are barred by the passage of time. The time that it would take for an order of the Speaker to attain finality is uncertain. The Election Commission of India is a constitutionally entrenched institution which is entrusted with the function of superintendence of and control over the electoral process. The ECI, which is a constitutional authority, cannot be prevented from performing its constitutional duties for an indefinite period of time. Proceedings before one constitutional authority cannot be halted in anticipation of the decision of another constitutional authority. In arriving at this decision, it is not necessary for the ECI to rely on the test of majority in the legislature alone. In cases such as the present one, it would be futile to assess which group enjoys a majority in the legislature. Rather, the Election Commission of India must look to other tests in order to reach a conclusion under paragraph 15 of the symbols order. The other tests may include an evaluation of the majority in the organizational wings of the political party, an analysis of the provisions of the party constitution, or any other appropriate test. Then we deal with the judgment in Sadiq Ali's case, and having dealt with the judgment, we say the disqualification proceedings before the Speaker cannot be stayed in anticipation of the decision of the ECI. In cases where a petition under paragraph 15 of the symbols order is filed after the alleged commission of prohibitory conduct, the decision of the ECI cannot be relied upon by the Speaker for adjudicating disqualification proceedings. If the disqualification petitions are adjudicated based on the decision of the ECI in such cases, the decision of the ECI would have a retrospective effect. This would be contrary to law. The question before this court is, what is the impact of the deletion of paragraph 3 of the 10th schedule? This question has arisen in the context of both the factions of the Shiv Sena claiming to be the real Shiv Sena. In effect, this points to the existence of a split within the SSLP. However, no faction or group can argue that they constitute the original political party as a defense against disqualification on the ground of defection. The inevitable consequence of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members who face disqualification proceedings. In cases where a split has occurred in a political party or in a legislative party, members of neither faction may validly raise the defense that they are the political party in the event that each faction files petitions for the disqualification of members of the other faction. The defense sought to be availed of must be found within the 10th schedule as it currently stands. The deletion of paragraph 3 impacts the proceedings under paragraph 2(1)(b) as well. When there are two whips appointed by two or more factions of the political party, the speaker, as held in the preceding section of the judgment, decides which of the two whips represents the political party. Thus, the adjudication of the speaker on whether a member must be disqualified under paragraph 2(1)(b) would also depend on the decision of the speaker recognizing one of the two or more whips. We accordingly answer the question referred to us as noted in paragraph 32F of the judgment. To avert a no confidence motion, the incumbent government may not advise the governor to convene a session of the assembly, and the speaker may adjourn the sitting of the house to prevent voting for granting leave to move a motion of no confidence. If the speaker and the government attempt to circumvent a no confidence motion, the governor would be justified in exercising the power under Article 174 without the aid and advice of the Council of Ministers. Now we have dealt with the role of the governor in the present case. The petitioners have urged that the governor was not justified in reaching the conclusion that he did on the basis of the resolution dated 21 June 2022 because 1. The 34 MLAs belonging to the Shiv Sena did not express their intention to exit the Maha Vikas Aghadi government, and 2. The MLAs who signed the resolution constituted a faction of the SSLP. Although the resolution dated 21 June 2022 specifies that some MLAs of the SSLP were dissatisfied with the functioning of the MVA government, it does not record their intention to withdraw support from the government. Among the 34 MLAs who signed the resolution dated 28 June 2022, a few were also ministers in the government. On the basis of this resolution, the governor concluded that a majority of the Shiv Sena MLAs have given a clear indication that they intend to exit from the Maha Vikas Aghadi government. The assembly was not in session when Mr. Fadnavis and 7 independent MLAs wrote to the governor. However, there was no attempt made by the members of the opposition parties to issue a notice for a no confidence motion against the incumbent government. The governor had no objective material on the basis of which he could doubt the confidence of the incumbent government. The resolution on which the governor relied did not contain any indication that the MLAs wished to exit from the MVA government. The communication expressing discontent on the part of some MLAs is not sufficient for the governor to call for a floor test. The governor ought to apply his mind to the communication or any other material before him to assess whether the government seemed to have lost the confidence of the House. We use the term opinion to mean satisfaction based on objective criteria as to whether he possessed relevant material and not to mean the subjective satisfaction of the governor. Once a government is democratically elected in accordance with law, there is a presumption that it enjoys the confidence of the House. There must exist some objective material to dislodge this presumption. The MLAs did not express their desire to withdraw support from the MVA government in the resolution dated 21 June 2022. Even if it is assumed that the MLAs implied that they intended to exit from the government, they only constituted a faction of the SSLP and were at most indicating their dissatisfaction with the course of action adopted by their political party. The political imbroglio in Maharashtra arose as a result of party differences within the Shiv Sena. However, the floor test cannot be used as a medium to resolve internal party disputes or intra-party disputes. Dissent and disagreement within a political party must be resolved in accordance with the remedies prescribed under the party constitution or through any other methods that the party choose to opt for. There is a marked difference between a party not supporting a government and individuals within a party expressing their discontent with the party leadership and functioning. The governor is the titular head of the state government. He's a constitutional functionary who derives his authority from the Constitution. This being the case, the governor must be cognizant of the constitutional bounds of the power vested in him. He cannot exercise a power that is not conferred on him by the Constitution or a law made under it. Neither the Constitution nor the laws enacted by Parliament provide for a mechanism by which disputes amongst members of a political party, particularly, can be settled. They certainly do not empower the governor to enter the political arena and play a role, however minute, either in inter-party disputes or in intra-party disputes. It follows from this that the governor cannot act upon an inference that he has drawn that a section of the Shiv Sena wished to withdraw their support to the government on the floor of the House. It is true that the letter dated 25 June 2022 sent by some MLAs of the Shiv Sena to the governor requesting him to issue directions to the appropriate authorities for the restoration of their security details mentions that those MLAs no longer wanted to be a part of the corrupt MVA government. However, this cannot be taken to mean that they had withdrawn their support on the floor of the House. Nothing in any of the communications relied upon by the governor indicates that the dissatisfied MLAs from the Shiv Sena intended to withdraw their support to the Chief Minister and the Council of Ministers. At the highest, the various communications expressed the fact that a faction of the MLAs disagreed with some policy decisions of the party. The course of action they wished to adopt in order to air their grievances and redress them was, at the time the floor test was directed to be conducted, uncertain. Whether they would choose to enter deliberations with their colleagues in the House or in the political party, or mobilize the cadres, or resign from the assembly in protest, or opt to merge with another party was uncertain. Therefore, the governor erred in relying upon the resolution signed by a faction of the SSLP MLAs to conclude that Mr. Thackeray had lost the support of the majority of the House. Second, the governor relied on the letter dated 25 June 2022 from 38 SSLP members, claiming that the security provided to them and to their families was illegally withdrawn. The MLAs claimed that the security was withdrawn to coerce them into continuing to support the MVA government against their free will. Therefore, they demanded the restoration of the security provided to them and to their family members. After receiving the letter, the governor issued directions to the state police to provide adequate protection to the MLAs, the members of their families, and their property. However, the lack of security to the MLAs has no bearing on the question of whether the government enjoys the confidence of the House. The appropriate response of the governor in such cases is to ensure that security that they were lawfully entitled to continues to be provided to them if it has been removed. This was an extraneous reason that was considered by the governor. The third communication that the governor relied on is the letter dated 21 June 2022 addressed by Mr. Eknath Shinde to the Deputy Speaker, stating that the appointment of Mr. Ajay Chowdhury was illegal. The governor may not inquire into or express an opinion on the validity of proceedings of the legislature. That is exclusively within the domain of the legislature itself, or in certain circumstances, discussed in the previous segment of this judgment, within the domain of courts. The discretionary power of the governor under Article 163 of the Constitution is limited to situations where a constitutional provision expressly provides it, or where the Constitution cannot be construed otherwise than to grant such discretion. Hence, the governor ought not to have relied on the letter dated 21 June 2022. In any event, the contents of the letter did not indicate anything to suggest that the then Chief Minister, Mr. Thackeray, had lost the confidence of the House. Finally, the governor relied on the letters written by Mr. Fadnavis and 7 independent MLAs, calling upon him to direct Mr. Thackeray to prove his majority on the floor of the House. First, both Mr. Fadnavis as well as the 7 MLAs could have well moved a motion of no confidence. Nothing prevented them from doing so. Second, a request by some MLAs for a direction to the Chief Minister to prove his majority does not, taken alone, amount to a relevant and germane reason to call for a floor test. There must be some objective material in addition to a mere request to call for a floor test. In the present case, the governor did not have any objective material before him to indicate that the incumbent government had lost the confidence of the House and that he should call for a floor test. and the exercise of discretion by the governor in this case was not in accordance with law. Now on relief. Relying on Bommai and Nabam Rebia, the petitioners argue that this court has the power to restore the status quo ante and rule that the government with Mr. Thackeray as its chief minister is to be reinstated. However, this argument does not account for the fact that Mr. Thackeray did not face the floor test on 30 June 2022 and submitted his resignation. This court cannot quash a resignation that has been submitted voluntarily. Had Mr. Thackeray refrained from resigning from the post of the chief minister, this court could have considered the grant of the remedy of reinstating the government headed by him. The order of this court dated 29 June 2022 held that the outcome of the trust vote to be conducted on 30 June 2022 shall be subject to the final outcome of this batch of petitions. Since the trust vote was not held, the question of it being subject to the final outcome of these petitions does not, therefore, arise. Conclusions. In view of the discussion above, the following are our conclusions. A. The correctness of the decision in Nabam Rebia is referred to a larger bench of 7 judges. B. This court cannot ordinarily adjudicate petitions for disqualification under the 10th schedule in the first instance. There are no extraordinary circumstances in the instant case that warrant the exercise of jurisdiction by this court to adjudicate the disqualification petitions. The Speaker must decide the disqualification petitions within a reasonable period. C. An MLA has the right to participate in the proceedings of the House regardless of the pendency of any petitions for their disqualification. The validity of the proceedings of the House in the interregnum is not subject to the outcome of the disqualification petitions. D. The political party and not the legislature party appoints the whip and the leader of the party in the House. Further, the direction to vote in a particular matter further, the direction to vote in a particular manner or to abstain from voting is issued by the political party and not the legislature party. The decision of the Speaker, as communicated by the Deputy Secretary to the Maharashtra Legislative Assembly dated 3 July 2022, is contrary to law. The Speaker shall recognize the whip and the leader who are duly authorized by the Shiv Sena political party with reference to the provisions of the party constitution after conducting an inquiry in this regard and in keeping with the principles discussed in this judgment. E. The Speaker and the Election Commission of India are empowered to concurrently adjudicate on the petitions before them under the 10th schedule and under paragraph 15 of the symbols order respectively. F. While adjudicating petitions under paragraph 15 of the symbols order, the ECI may apply a test that is best suited to the facts and circumstances of the case before it. G. The effect of the deletion of paragraph 3 of the 10th schedule is that the defense of a split is no longer available to members facing disqualification proceedings. The Speaker would prima facie determine who the political party is for the purpose of adjudicating disqualification petitions under paragraph 2(1) of the 10th schedule, where 2 or more factions claim to be that political party. H. The governor was not justified in calling upon Mr. Thackeray to prove his majority on the floor of the House because he did not have reasons based on objective material before him to reach the conclusion that Mr. Thackeray had lost the confidence of the House. However, the status quo ante cannot be restored because Mr. Thackeray did not face the floor test and tendered his resignation. And I, the governor, was therefore justified in inviting Mr. Shinde to form the government at the behest of the BJP, which was the largest political party in the House. This batch of writ petitions is disposed of in terms of the conclusions and directions recorded above.
Grateful to your Lordship.
Full immediately. Without correction.
Deeply obliged.
No, obliged, your lordship.
Deeply obliged.
Thank you for all your assistance. We must thank the members of the bar.
No, we are really
You can never rise
very
above the
patient
thoughts of
hearing.
which we come. Thank you.
Thank you.
Check, mic check, audio check. Check, audio check, mic check. Check. Audio check. Mic check, audio check. Check, audio check. Check. Check, audio check. Madam, back. Check, audio check. Check. Check, mic check.
Tomato.
Dr. Singhvi, we've been, from last evening, we have been getting an incessant flow of material in the electronic form. Now we are in rejoinder, and rejoinder we get 500 pages of material.
I am not the culprit, Wallace, at least fortunately. I give mine. I've got 6 more paras, Wallace. I'm not.
Ah, right. Justice Bhatt called it an electronic dump, you know.
It's an electronic dump.
Anti-dumping philosophy. We will not permit dumping and.
Well, at least 3 of us are not the guilty party, Wallace. We are.
On the lighter side, I've joined the proceedings physically to make sure all of you finish quickly.
By 3 o'clock. By 3 o'clock. We finish at 3 o'clock.
I'll be very quick. The Lordship has
Only
now,
points.
Wallace,
Just points now, yeah.
only points. I've only got a few paras to read. Will hardly take 15 minutes. Whereas your Lordships has heard the trend of my arguments yesterday.
Yes.
Your Lordship knows the Mullah's angularities, if I may say so, and the Mullah's pointed thrust of it. It is not a perfect world in the world in which we are projecting. We respectfully agree and bow down that there are angularities. But Mullahs, for a matter like this, my only submission is that these are angularities which your Lordship have in the past surmounted and should and can do it in this case. So I'm not projecting a perfect world. Number 2, Mullahs, we had done with the 3 options which your Lordships finished in Mullahs para 14, just above 15. Since your Lordship Mullahs has a view about notice and objections, almost 1/3 of my written submissions are notice and objections. So therefore, Mullahs, very little is left now. Let me, Mullahs, go to para 15. My submissions, my Lord has got. Each of my Lords.
It would not follow.
Yes. Justice Kohli, Justice Paul has got it.
Yes. You're looking to your rejoinder submissions.
Yes.
Which paragraph?
15, 1-5.
Yeah.
Yes, my Lord Justice Paul doesn't have it.
The rejoinder submissions likha hai.
क्या लिखा है?
It starts with it would not follow from.
It will not. Correct. So the conclusion after the 3 options is
See, we look for it. I haven't. Documents by Dr. Singh. Please start.
Yes, Dr. Singhvi.
15. It would not follow from this approach that non-heterosexual Hindu couples who marry under SMA would be excluded from legal succession regimes altogether. Like non-Hindu interfaith couples, they are governed by the ISA. This is because 21A on its own terms assumes that marriages that it applies to are also capable of being valid under HSA. Last 4 lines is the conclusion. Till the right of non-heterosexual couples to marry under HMA is adjudicated upon by this court or provided for by the legislature, non-heterosexual marriages simply do not meet the preconditions for the triggering of 21A. This is the exclusion of 21A, which was my 3rd option. I'm actually, if at all I'm forced to, I'd canvass the 2nd option, but I'm completing on the 3rd option. Each are your Lordship's choice, but the 2nd option would be one thing which your Lordship may see. Now I come to Mullahs, 2 or 3 special cases and I'm done. very quickly. One is this heteronormative settings. That is a separate, discrete head. Kindly bear with me just for a few minutes in that. Women in particular, in heteronormative setting. Well, just before I read it, one sentence. We on this side, me, is challenging only the exclusionary provisions. The whole thrust is exclusionary provisions, namely those which discriminate against me based on my ascriptive characteristics. Now read my para. In a nutshell, this subheading contends that several provisions of the SMA which attempt to create a protective arc for women in a heterosexual marriage, treating them as structurally the more vulnerable gender. In the old days, we used to call it the weaker sex, but that's not quite a correct word. Need not be interpreted in favor of either partner in a non-heterosexual marriage, which proceeds according to a gender-neutral approach. The stand of the petitioners fully answers and takes care of the respondents' wrongful contention that a gender-neutral approach to SMA defeats the purpose of certain provisions which are enacted to counter unique gendered situations. Example, rape, sexual violence. If the aforesaid gender-neutral approach of the petitioners, eschewing the sections dealing with preferential protective treatment of women under the SMA is accepted, the diverse contentions of the respondents, the other side, example those relating to section 27, would not arise. In that sense, this set of submissions by the respondents is either a red herring or attempts to set up a straw man in the name of the petitioners and then triumphantly shoot it down. Petitioners submit that these grounds and sections of the SMA, which deal with important gendered and heterosexual settings, namely the more vulnerable woman partner protection provisions, and legal protections, are not part of their prayer for marriage equality. The petitioners are not seeking interpretation of every gendered word in the SMA in a gender neutral way. We are only assailing those parts of the SMA that require a constitution compliant reading on grounds of discrimination and exclusion of non-heterosexual couples. It is you who are putting this in my mouth and say there is insuperable problem for the judges. I am not concerned with protective clauses in or one-sided clauses like rape, etc., which will necessarily apply in a heteronormative setting. Hence, the focus of interpretation similarly has to be on the discriminatory aspects of the Act that are relevant to and exclude non-heterosexual couples. I'm on exclusion only. Those provisions that specifically deal with heteronormative settings and offer rights protections to women, qua men, do not require a constitutionally compliant interpretation. So you are putting it into my mouth and then saying judges cannot do it, it's impossible, etc., etc. It is crucial to clarify that this is not a case of anomalous cherry picking. I'm just giving a few lines. Justice Bhatt also raised it when I had opened this quite rightly. It is not a case of cherry picking different interpretive regimes for the same words within the same statute. I'm addressing Your Lordship in para 19. Returning to the issue of the underlying thrust of legislation and a constitution compliant reading, when it comes to the use of gendered terms to specifically address gendered imbalances of power, physical, normative, and therefore achieve substantive equality, limiting such terms to their gendered heterosexual context is consistent with the law's underlying thrust. So don't put in my mouth that I'm challenging it and then say that you can't challenge it. I don't need to and I'm not. It can therefore be seen that the petitioner's approach is entirely consistent with my two anchoring points. My anchors are twofold. One being the underlying thrust of the SMA, which already exists as a secular platform for non-personal law couples mostly, and the fundamental rights in the Constitution is the other anchoring point. In other words, it is permissible for the specific interpretation of different gender terms across the SMA to be interpreted with a view to ensuring that their interpretation serves the underlying thrust of the SMA and the principles of non-discrimination and equality. Therefore, my conclusion is para 21. Hence, this Honorable Court may declare that provisions of SMA with respect to solemnization and registration of marriage are extended to non-heterosexual couples, except to the extent that provisions of the SMA or any other law in force are enacted for a wife against husband in a heterosexual marriage or for a woman against a man in a gender-specific context. That is basically the rape category, the sexual violence category. a list of such provisions clearly, well, I have given in annexure 2, which is at page 27, a whole list of such provisions for your lordships, but I have culled them out just for ease of reference. No. Interaction with other laws that include matrimonial rights. This is another category, very small category. Respondents' also argument that the bundle of allied rights that accompany marriage cannot be addressed by this court, as they involve multiple legislation and complications. Petitioners disagree. A valid marriage in the eyes of law is like an index or key to other secular matrimonial and family laws. The current scheme holds that only a man and woman married under the Act can qualify as a legally married couple, entitling them to benefits under other statutes that require marriage status. Statutes that use the gender-neutral word spouse require no further changes. Rights under these statutes will naturally flow if the Supreme Court interprets spouse to include some gender and queer partners under SMA. This is a separate list, annexure 3 at page 30 of my note. You should note the page there at page 30. This is, Malos, that category where your lordship has to only hold that spouse includes a queer couple, but not that your lordship will say that wife includes spouse or husband includes spouse. Statutes that use gendered words like husband and wife may be interpreted in gender-neutral way as persons, consistent with the interpretation for marriage equality. Hereby clarified that the present set of petitioners have limited submissions specifically to the issues arising from the SMA and on succession issues limited to the ISA. That is my option 2 really. And are not seeking this honorable court's interpretation for the diverse list of acts that use gendered words which may be reserved for future interpretation. It is further submitted not open to the respondents to argue that the petitioner's fundamental rights may not be recognized simply because it will open the pathway to further litigation, seeking the full and equal import of the rights that may be recognized here. The forward march of the law and of fundamental freedom has been based on litigation such as these, and the recognition of fundamental rights of citizens cannot be held hostage to the false virtue of preventing further litigation. The directions the lordship issued in Malas Navtej, have they been complied with by less than legislation? Your lordship required less than legislation there. And you are told that legislation will solve all our problems now, Malas. Your lordship required something very minor compared to, in my opinion, under that. Has it happened? Then age related. I must be consistent with that. I'll make Malas. Again, please keep the perfect solution is never there. I think it's a good solution we are trying to offer. I'm not suggesting it is fully logically consistent, but it's a workable solution. Kindly see this. On 4C, Malas, same-sex couples, the provision may be read as prescribing 18 for both parties in a lesbian relationship and 21 for both in a gay relationship. In the case of transgender, so there are only two categories, lesbians or homosexuals, there will be 18 and 21. Which ages your lordship already has in the Act. In the case of transgender, this is on the graded hierarchy of LGBTQII++. Whichever gender sex they identify as, the concerned age requirement would apply. That is, a trans man would have to be subject to 21 and a trans woman would be at 18. Because the whole point of that II and plus is that they have to declare themselves as a woman or a man. Then, Malas, the approach in the previous paragraph leaves open the question of age qualification for persons seeking to marry who do not identify as either man or woman. Now, Malas, I am giving your lordship a theoretical category, but yes, it is a category. It's a very small category, but I am still, Malas, giving it because I don't want to avoid it. Petitioners suggest that the following alternative routes of interpretation may be adopted to ensure inclusion of non-binary and intersex individuals. It's a small category. It should not defeat my entire case. It's largely a theoretical category, but please see the solution. First, the SMA's silence on the age of qualification for persons other than men or women may be read as imposing no restriction beyond that imposed by other laws that stipulate the age at which the persons became capable. In other words, this category, universal 18. In one word, I'll skip the paragraph. 18, which is your lordship's age of consent for 99.9. Now, civil union, I'm done. That's the last point. Well, with great respect, civil union at para 29 is no solution. I'll explain in 2 minutes. Civil union is not a solution, not an equal alternative. Third line in 29. Petitioners respectfully submit that civil unions do not address the constitutional anomaly presented by exclusion of non-heterosexual couples from the legal and social institution of marriage. A civil union is not a marriage. It is both the marriage as an access to marriage and equality in marriage that we are seeking. Now, just see this rather interesting case from Supreme Court of New Jersey. In that case, Lewis and Harris, this is directly going to be relevant. Third line. The state's marriage laws excluded non-heterosexual couples like today. The majority held such laws to be unconstitutional. So your lordship struck down those laws. But remedy your lordship gave was civil union, to be remedied either by amendment or by creation of a separate civil union status for queer couples. Chief Justice Porritz, with the other two judges, dissented. And this dissent later on became the majority view in the US. I'll read the dissent very briefly. We must not underestimate the power of language. Labels set apart people as surely as physical separation on a bus. This is going to be important, on a bus or in school facilities. Labels are used to perpetuate prejudice about differences that in this case are embedded in the law. By excluding same-sex couples from civil marriage, the state declares that it is legitimate to differentiate between their commitments and the commitments of heterosexual couples. Ultimately, the message is that what same-sex couples have is not as important or as significant as real marriage, that such lesser relationships cannot have the name of marriage. Whereas Oberfell, which accepted it, did not cite Chief Justice Porritz, but it adopted this view, which I have quoted. The original source was the dissent. Has become the prevailing one in para 31. It has been held that equal protection requires marriage. Indeed, any other view would militate against India's own jurisprudence on substantive equality. Relegating non-heterosexual relationships to civil unions and denying their access to the marital institution would send those in such relationships a clear message of subordination, that their relationship is less than, quoted, inferior to relationships that comply with the entrenched heteronormative order. Petitioners' relationships do not deserve the name of marriage. By doing so, civil union status would undermine full and equal. It's full is one word, equal is the other. Social, economic, political, and cultural participation, and contribute to the petitioner's subordination. That was my last point. I may be perhaps guilty of slight exaggeration, but I think it's an appropriate analogy. The segregation doctrine of separate but equal is what I've said in the last, para 33. A civil union says, yes, you are equal, but you are equal in that side of the table, within your separate enclave. And within this, my enclave, this is a different equality. This separate but equal, your lordship is frowned upon. In all civil rights issues, this should not be a new creation judicially. But as I am ended, your lordship may reconsider. If your lordship feels para 34 onwards is a strong argument for notice and objection, I'm not arguing it.
Right.
I'm not arguing.
Thank you, Dr. Singhvi.
Don't do my submission.
Thank you, Dr. Singhvi.
I'm very deeply obliged. For
Thank you, Dr. Singhvi. Yeah.
Very briefly, Millet.
Yeah.
I start, Millet, with a factual clarification with regard to the nature of the prayers, because one of the observations from the bench yesterday was, where did you raise the question of virus? Now, Millet, in my writ petition number 93 of 23, the very first prayer is challenging 4C to the extent it excludes LGBTQIA couples as unconstitutional. And in that specific context, an argument was addressed on the fact that the question was, is it restriction or lack of recognition? And the argument was, it is lack of recognition, and lack of recognition leads to a denial of the equal protection of laws. And therefore, my respectful factual clarification is the submission was on the virus. Having said that, my lords, apropos the observations of the bench on the possibility of giving a constitutional declaration, but not more than that, leaving it to the legislature thereafter to enact laws. And, my lords, there were some instances which the bench didn't specifically mention, but I am making a guess that perhaps 3 recent instances which the bench might have had in mind, where a declaration was followed by legislation, would be, my lords, triple talaq. The next would be transgender. Third would be data protection. Now, my lords, those 3 are examples where the majority, when I'm talking of majority, now I mean, my lords, the majority as reflected in the institution of the legislature, would have had no serious problem at all. Because, my lords, triple talaq was something which shocked the conscience of people across the board, across communities. And therefore, once this court gave a declaration to pass that law penalizing, was a matter for fairly easy legislative consensus.
But that's not something which the court can presume.
No, no.
That
all
we
that
will
I'm-
decide whether to give a declaration or not, how we anticipate Parliament would have, or is likely to respond.
No, with respect.
That's
No,
not for
with-
the court to take an assessment.
No, with respect, the purpose of showing this, giving these couple of examples was only this. That there can be such instances. One is not inviting the court to record a declaration that here it may be different. No, I'm not saying that.
You are
All
saying the subject matter is such that you can't expect the majority.
Lordship, please, because take for instance transgender. There is a broad societal sympathy for transgenders in any case,
The constitutional is.
because transgenders play a social role in our society. Therefore, this was not a matter of difficulty. But here, this is now an
Same thing.
this is popular minority. This is an unpopular minority across communities, across ideologies. And this is where, when the court says and often says that it is the protector of unpopular citizens, of the rights of unpopular citizens, this is the kind of situation where I would respectfully invite this honorable court to walk the full mile and not stop at a constitutional declaration. And what was suggested to the court, in my respectful submission, was a constitutionally permissible method. And it was in that context that we advocated reading in of the provisions of the Special Marriage Act in the manner suggested by us. I am not repeating that for the sake of, and my submissions and rejoinder are in a 7-page note, my lords, in volume 14. Therefore, my lords, without taking my lords to the note, my lords, I am only referring to the main points there. Therefore, we have, my lords, given instances, 3 instances of our court reading in, including, my lords, Madhu Kishwar, Geeta Hariharan, and a recent Bengal cooperative case, my lords. We have given a Canadian example, we have given a South African example. These are all cases of reading in, which is legitimately resorted to, and with respect ought to be resorted to. With, my lords, 3 riders. With, my lords,
Indian example, Madhu Kishwar, Geeta Hariharan, and
it's a recent Bengal cooperative society case. My lords, I've given the reference.
Right.
Bengal Secretariat Land Mortgage Bank. I've given the reference in my note, my lords. Justice Bhatt was a party. Justice Bhatt was a party, my lords, to that. Right? I think Justice Pardiwala wrote the judgment. Now, my lords, this submission of mine, I am subjecting my own submission to 3 caveats, 3 riders. 1, the special provisions for a wife in a heterosexual marriage under the Special Marriage Act, each one of them will stand as they are because of the constitutional mandate, the higher constitutional mandate of Article 15(3). Because of 15(3), any provision which is wife specific under the Special Marriage Act will stand as it is without being subjected to any kind of interpretative exercise.
That's what Dr. Singhvi also
Lordship, please.
said in his written submissions.
Second, words, gender-specific laws concerning man and woman, including penal laws, will not be subject to any interpretative exercise. Third, my lords, religious personal laws will not be interfered with, and Section 21A may be borne in mind in this connection.
And section?
21A.
21A.
Yes.
Sorry, the third one, will you repeat, Mr. Ram?
I'm sorry,
The
but
third one. What did you say is the third one?
Section 21A, for instance, my lords, with regard to
Success.
the personal law governing the parties, that will not be touched. Now I'm just making two more quick points, my lords. This is in response to a powerful argument by Mr. Dwivedi that marriage has always been viewed by society as a man-woman union. And that cannot be touched upon. Now, in my respectful submission, that is really a bit of circular reasoning. And the real test to be applied is this. Is traditional reading of marriage as a man-woman union discriminatory against same-sex couples? That should be the test, my lords, not the origin of the institution. Just as the original intent doctrine may not apply to the constitution or to reading of a statute, similarly, a particular social institution today has to be seen in this light, whether it violates, it's discriminatory against same-sex couples.
Beyond constitutional law. See, you are going beyond the law. You are talking of society. The society
No, no.
being discriminatory has never been the centerpiece of.
No, I'm sorry. The purpose of
You will have to
referring to
formulate it differently.
no, I'm grateful, Lords. Let me reformulate it. As part of the constitutional argument of the other side, what your lordships were told was that a constitutionally recognized union so far is understood as a man-woman union. That is the thrust of the argument.
Is it? And bring it down further.
Lordship.
What was argued was not constitutionally recognized. What was argued was this is a legally recognized. And what you seek is that your union, the union of same-sex couples, should receive similar, you should have a right to similar legal recognition.
Lordship, please, Lords. Lordship, please, Lords. I'm grateful, Lords. Final submission, my lords, in reiteration of what Dr. Singhvi said and highlighting again the facts of that particular section of society which my two clients, my lords, the Dalit girl and the OBC girl, being hounded by their families there, the argument was that the notice provision would render illusory any right to marry. Therefore, whether your lordships grant us the prayer with regard to the Special Marriage Act, or whether your lordships limit yourselves to declaring a constitutional right, any declaration in our favor would, with respect, be illusory if we are subject to notice provisions. And finally, again, even if your lordships were to be giving only a constitutional declaration, the need for a protocol, whether it's protection under the Special Marriage Act or whether it is a protection of a constitutional right which your lordships may be declaring, unless vulnerable couples are protected by a Shakti Vahini like protocol, which I had referred to in my submission minutes, we would not be getting any relief. Therefore, I would earnestly request my lords to factor this into any relief which your lordships will be giving. I am grateful.
Thank you, Mr.
May it please the Lordship. My Lord, I have circulated yesterday submissions in rejoinder, my Lord, in Zainab Patel. And I want to only focus the time that your Lordships will give me to respond, my Lord, to the legal objections taken by the union and the respondents about, my Lord, the relief sought in our petition. I hope, my Lord, your Lordships have that file. Submissions in rejoinder, my Lord, of myself. With that, I have begun with that. There are 11 subheadings. I don't propose to read them, but take your Lordship to the points they have raised and respond to them. My Lord, after all this churning, churning, my Lord, as I see it emerging, which will call for your Lordship's pronouncement. A step more than the right to marry is there a corresponding obligation, a correlative duty in the union to recognize, my Lord, the association of non-heterosexual couples as married couple in a non-discriminatory manner? That is, my Lord, one is I will establish prima facie that I have a fundamental right to marry. I don't want to confine myself to the statutes, my Lord. And I will tell you, Lordships, why very briefly. Having demonstrated that, it has come in discussion, it has been argued that who stops you? By all means, have a celebration, have a marriage. But if you seek affiliation or recognition, can you vest in the respondent an obligation, just as they have, my Lord, granted it for non-heterosexual couples? That will be the primary question, my Lord, because it was argued throughout that nobody stops them from calling their association a marriage, but don't expect recognition or affiliation. I'm using the word affiliation, my Lord, in a broader sense.
You are trying to locate a duty.
Duty, my Lord, duty.
Your
Now, my Lord,
question is locating a duty should stand on a different footing from that of discrimination.
locating the duty will discrimination, and for that, my Lord, we will have to go back a bit. As my Lord, the Honorable Justice Butt rightly said, put yourself in the armchair as if you are in 1954. Now, my Lord, put yourself in the armchair as if you are in 1954. Sir, I'll address, my Lord, the Honorable Justice Narasimha's question. My Lord, I'm going to establish a right, and then, my Lord, put the duty independent of that. In 1954, no doubt there was a statute of 1870. Sorry, my lords are in conference. An 1872 statute, my lord, which had an onerous condition that you must give up your religion. The 1872 Special Marriage Act, which was repealed by the 1954 Special Marriage Act, said for those who do not profess Hindu, Buddhist, Christian, Sikh religion, because you have to give up the religion, my lord. Now, in 1950, when the constitution came into force, marriages were by personal laws. Entry 5 in list, my lord, 3, the field of legislation was demarcated. If, my lord, an interfaith couple had come to your lordships and said, I don't want to give up my religion, I want the same status that people who have gone the religious route and have come in an association of marriage are being given by the state in all their activities, my lord, in terms of pension, insurance, and all those things. In my respectful submission, your lordships would have found that right and found a positive obligation. Found a positive obligation in commanding the state. Your lordship would not have turned the interreligious couple at the door and said, there is no legislation today. The legislation says you have to give up your religion, the 1872 Act. Your lordship would have found that to be unconstitutional, number one. And your lordships would have recognized their right to marry without giving up their religion, my lord, in an interreligious marriage. Today, my lord, after Navtej, in 50 also, my lord, this 377 had considered this association as unnatural. The natural association was of a man and a woman cohabiting without force. But this was unnatural. Consensual cohabitation was unnatural. So it could not have recognized. They would have had a valid defense in saying it's an offense. It became natural, purely natural. With Navtej having, my lord, exorcised from 377 the penal part of the provision. Now, my lord, in this scenario, if, my lord, marriage is the ultimate union as has been developed, my lord, in the jurisprudence that we have placed.
Nathan,
Yes.
now, no doubt this is a very this hypothesis is very attractive to dwell upon in a 2023 court. But the fact remains that in the 1950 court, viewed fundamental rights essentially very differently. With A.K. Gopal and etc.
My lord, we will have
to transpose ourselves back then,
No, my lord.
we had a far segregated or fragmented view of fundamental right. What you're doing essentially is placing that situation and transposing it to the present
My lord,
context.
My lord raised that argument of what would have been the situation between 50 and 54. It's a very important, my lord,
See,
question.
you see, it's not just interfaith. Till 1946, even intercaste marriages were prohibited.
So, my lord,
So the 54 Act went beyond religion. It actually demolished all those other barriers. So in that sense, that statutory intervention brought that about.
now,
So both parts, see, you may be right. Now the question is to take forward that hypothesis. How do you bolster it?
yes.
With which kind of precedent do you bolster?
Yes, my lord. Kindly have a look at my note.
You are relying on that Narula. You're relying on Salmon.
I am relying
You're relying on Cooley.
Salmon for, my lord, right and correlative duty.
Yes, yes.
I am relying on, my lord, the positive obligation judgments,
And you're relying on Cooley's.
Cooley's
declaration.
constitutional limitations. I am relying on, my lord, what will of the people is. It is argued that will of the people in the context of a referendum. Will of the people, your lordships have said, is the constitution. Your lordships in constitution benches have said will of the people is already reflected in the constitution.
Going to rely on those passages in B.R. Kapoor also.
We are Kapoor also, my lord. Will of the people. My lord. The correlative duty, I have even gone a step further and argued in the alternate. Assume it is a privilege they are extending. Even in a privilege, your lordships have said you can't discriminate. In the most, my lord, noxious of trades,
Yes, you are right.
if you, now what is this, my lord? Is it a right they confer by exercising their duty?
Nandraj Jaiswal.
Nandlal Jaiswal, I quoted Nandlal Jaiswal in the note.
You did.
Now, my lord, let me assume by forming statutes, by regulating it, they are giving some rights, my lord, or deem it as a privilege. In both, argue on both prongs, my lord. Can you now discriminate? Can you now discriminate, my lord, is the question. So the real question before a lordship is, subject to correction, my lord, the right to marry, yes. Is there a duty in them to recognize this association as a marriage and extend the privileges which heterosexual couples have, my lord, come to enjoy? And if your lordship asks that question, my lord, some water.
Not to sound a spoiler, just one question. Then in that
No,
case,
no, my lord, it's
the
only your
next-
lordship's, my
Next
lord.
case would, the
My lord,
next
queries
next
which bring out.
question would be,
Yes,
what all relationships would you locate the duty?
yes.
In the case of a live-in also, then you will say that the law should cater to every kind of relationship.
No, my lord. My lord, that is an argument addressed. Incestuous relationship was argued. I'm just
We will
giving
not take it
illustration.
to that extreme.
Three people coming together was argued. My lord, 1 minute, I can't. Whatever you are giving the heterosexual couple, there I am putting it on discrimination. Today, incestuous relationship is barred in heterosexuals. Prohibited degree is barred in heterosexuals. My lord, any other, my lord, three people coming together, the argument Mr. Sibal gave is barred in heterosexuals. My discrimination argument will fall flat. But if you are extending, my lord, a certain right, call it right, call it privilege, can you then, my lord, post Navtej, when you have called this relationship natural, when it is no longer unnatural, and when your lordship say we have to be put on even platform, don't they have, my lord, as Saman says, if you have this much, they have, my lord, a duty which they have extended to, my lord, a set of heterosexual couple.
Mr. Vishwanathan,
Yes.
I mean, just as a matter of jurisprudential curiosity, I dealt with this argument in my
Dissent.
in
Aadhaar.
Aadhaar. The only problem it's a dissent. And if you see my Aadhaar judgment, which is 2019 1 SEC, it is at 664.
We are given it.
There's a segment called Development as Freedom.
Yes, my lord.
And where, after citing Amartya Sen and Martha Nussbaum, and adverting to the capability theory, I referred to Henry Shue, and I say Henry Shue suggests that rights give rise to corresponding duties.
Yes.
These duties include: 1, a duty to respect; 2, a duty to protect; and 3, a duty to fulfill. Just see this. I mean, just as a.
My lord, no, my lord, that is exactly, my lord, we should have
Just
placed
keep,
that.
you have that?
We
by way?
read it in
Or
the
we can-
context.
I can
but-
share it with you if you
My
want.
lord,
The judgment is at, just see, at page 790. 790.
my lord, we are getting the book, my lord. My lord, in fact, what your lordship now read out echoes
Page
What?
790.
Saman.
And at page para 1222.
Yes.
Actually, see para 1220. The notion that liberty only consists of freedom from restraint does not complete the universe of its discourse.
Yes.
Broader notions of liberty are cognizant of the fact that individuals must be enabled to pursue their capacities to the fullest degree. Social and economic discrimination poses real barriers to access education, resources, and the means to a dignified life. This approach to understanding the content of freedom construes the ability to lead a dignified existence as essential to the conception of liberty and freedom. Then I cite development as freedom, which is Amartya Sen. Then para 1222.
Yes, my lord.
The notion of freedom as an agency has been developed by Sen as part of the capability theory. Then,
necessary consequence of focusing upon major sources of unfreedom in a social and economic perspective is that the removal of these restraints is essential to the realization of freedom. If true freedom is to be achieved through the removal of conditions which cause social and economic deprivation, the role of the state is not confined to an absence of restraint. On the contrary, the state has a positive obligation to enhance individual capabilities. Martha Nussbaum argues that realizing freedom requires the state to discharge positive duties. Nussbaum expresses a threshold level of capability
now just
below which
para 1224. In fact,
Yes,
the
Milord.
solicitor will remember Zoeb Hussain had made this argument
Yes,
actually.
Henry Shue suggests that rights give rise to corresponding duties. These duties include duty to respect, duty to protect, and duty to fulfill. Duties of respect embody a restraint on affecting the rights of others. Duties to protect mandate that the state must restrain others in the same manner as it restrains itself. The state's duty of non-interference extends to private individuals. The duty to fulfill connotes aiding the deprived in the realization of rights. This imposes a corresponding duty to create the conditions which will facilitate the realization of the right. The right which is protected for the individual will also signify an expectation that the state must create institutions enabling the access of facilitative measures or programs of action of an affirmative nature.
And the postulate is that these duties, affirmative duties of the state, extend in the welfare area. But I said that, this is not just confined to the welfare area, but it can include the more political or the more social.
They are obvious. This is, of course, in the realm of context of. But if you take the context of free speech,
Yes.
what is free speech if the situations are not conducive? If you are standing there and surrounded by 100 people who are armed, and the police is standing by, unwilling to help you,
Yes.
that freedom of speech is already illusory. There is no freedom of speech.
No freedom of
To that extent, the state is always under a duty to
Yes.
foster and facilitate the due exercise of fundamental rights. But this goes 2 steps beyond. First is you locate this as a right and then say you are under a duty.
Yes.
Even if we admit that there is a duty, what is that kind of duty? How do you crystallize that duty?
Yes, Milord. Then now that's the next question, Milord. Now kindly see, Milord, I want to place my case, dehorse this Special Marriage Act. Now, it has been argued without prejudice to them, Milord. I would not want to go from the statutory route at all. I somehow find, Milord, that this is a constitutional principle flowing from 21, and in deciding whether, Milord, an unenumerated right can be, Milord, inferred.
Vishwanathan, whatever, ultimately it will boil down to this. There is one constitutional doctrine which we have remained steadfast and constant to, that we cannot direct a legislation. We cannot direct the framing of a policy. We cannot enter into the realm of policy making or legislation. Now, short of that, what is the duty that you locate on
Yes.
him?
Now, Milord, the answer to respectful answer to that is even that principle, Milord, has various hues. Now, if there is a discrimination based on a core trait, as my Lord the Chief Justice called it in one judgment, even under inclusion, Milord, is no answer. We have developed it, Milord, in the note. A state may say, as it was said, Milord, in the special courts by Milord, the Senior Chief Justice, following West Coast versus Parish, that we will strike where the evil is most felt, or address the most imminent issue first. But in that, if suppose there are 10 Milord prongs which are available and 7 are covered.
Degrees of evil.
In the 7, what is the, Milord, legal answer in a claim for discrimination if in that 7 there is discrimination? Your Lordships have, Milord, pondered over it and said, if the discrimination is based on a core trait of an individual, we will not recognize that under inclusion. Keep the relief part aside, Milord. Both in, Milord, the case with my Lord the Chief Justice said, that is, Milord, this National South Indian River Interlinking case, or in the preemption case of Atam Prakash, where it was found that the included categories were keeping off consciously women. My lord, thus relatives of the same degree are excluded either because they are women or because they are related through women.
Constitutional prohibition. That would be relatively easier to answer
Yes.
because of 15(2). You have, I mean, you have proscribed category directly proscribed.
No, my lord, here they were excluded.
Yes, yes.
An
so
inclusion
you
of
can't-
women would have been justified.
No, you are excluding women. So
Excluding
you are
women.
excluding only.
No, my lord, I'm only saying this under inclusion argument is not a final argument. It can go home in certain circumstances, but there are circumstances, there are exceptions to it. My lord, look at National South Indian interlinking. While non-classification arbitrariness is tested based on the proportionality test, where the means are required to be proportional to the object, classification arbitrariness is tested on the rational nexus test. There is sufficient if the means share a nexus with the object. The degree of proof under the test would impact the judgment of this court on whether the law is under-inclusive or over-inclusive. A statute is under-inclusive if it fails to regulate all actors who are part of the problem. It is over-inclusive if it regulates actors who are not a part of the problem that the statute seeks to address. The determination of under-inclusiveness and over-inclusiveness and degree of deference to it is dependent on the relationship prong. Next para is very important, Milo. The nexus test, unlike the proportionality test, is not tailored to narrow down the means or to find the best means to achieve the object. It is sufficient if the means have a rational nexus to the object. Therefore, the court show a greater degree of deference to cases where the rational nexus test is applied. A greater degree of deference is shown to classification because the legislature can classify based on the degrees of harm to further the principle of substantive equality, and such classification does not require mathematical precision. Indian courts do not apply the proportionality standard to classificatory provisions, though the two-judge bench in Anuj Garg articulated the proportionality standard for protective discrimination on the ground of 15, held that less deference must be allowed when the classification is based on the innate and core trait of an individual. My lord, this is an innate trait of, my lord, non-heterosexual. An LGBTQ plus is a innate and core trait born with nature to them. How can it be said, my lord, that after Nautage, that you can have a partner, you can have cohabitation, you can live together, you can, my lord, enjoy your life together, but the ultimate fruition of marriage, which according to me is an essential right to enjoy the right to life fully for those who choose to marry, we will not recognize that and affiliate that. My lord, that, my lord, will not pass muster under inclusion. Then your lordship will find, even if there is no legislation, it will come under those narrow area of matters where a positive obligation will be found. That is not, my lord, a mandamus to mere mandamus to legislate.
Mr. Vishwanathan, even if the under inclusion is not valid in that
Yes.
sense, it's not a valid constitutional classification, because as you say, it is based on a core or innate characteristic.
Right.
Then there are two options to the court. You strike down the under inclusion as it is, or alternately, if there is an interpretative space available,
Yes, my lord.
you will mold the.
My lord, that has also been developed, my
But
lord.
then we are back to this, do we really have an interpretative space left in the SMA?
Yes.
If we have, of course, then you are right.
No, my lord, there
But
is
if
a
we
solution.
don't,
My lord, there is a solution for that, and I must thank two
then
young.
merely striking down an under-inclusive classification doesn't serve your purpose also.
No, my lord, I will, my lord, address that, my lord, independent of the reading in part. My lord, two young writers, my lord, who have written an article on transgender inheritance, reached out to me by email and furnished to me a very well-researched article produced by them, published in Karan Gulati and Tushar Anand. I have placed that for your lordship's in the Indian Advocates Review. They say, my lord, after Nalsa, your lordship's judgment led to the Transgender, my lord, Protection from Discrimination Act. But inheritance issues are not addressed there. Workability issues still may remain. But that will not deter Parliament from enacting that legislation and recognizing that right. Non-binary, my lord, people, the inheritance is a serious issue which is being addressed on a case-by-case basis. So workability will not hold back your lordships from declaring that there is a right in them to marry because that is an essential right to effectuate their right to life. My lord, I'll come back to my lord's query on the right. If so, my lord, that declaration will be worked out by Parliament. To that extent, my lord, there is a positive obligation. Property rights, my lord, other neighboring countries have amended their statutes, worked out proportion for transgenders based on male, female, non-binary. Non-binary, they give the average of the two, my lord. Look at how, and my lord, I am talking of Pakistan. I got the statute. Nepal has amended. These young authors have referred to it in their article, my lord.
Nepal recently, I mean, Sri Lanka, the bill
Sri
was
Lanka.
upheld.
Sri Lanka, my lord, they have
Bill was upheld.
upheld, my lord, upheld day before yesterday, upheld with, my lord.
And they've
So-
cited Navtej
Yeah,
itself.
now, Tej. No, my lord, when I transpose myself
bill has
to,
been upheld.
It is the bill which is upheld.
yeah.
Bill which is
My lord, they have a procedure. It happened in
Yes,
the
it
in the
goes-
devolution case also,
like an advisory jurisdiction.
advisory jurisdiction, my lord.
Even South Africa has that.
South Africa also has, my lord, this suspending it and leaving it to Parliament.
It is not a practice.
Yes. England has, my lord,
Mr. Vishwanath,
declaring
It
it.
is not a practice.
Yes. It is, my lord, mentioned in the
It
article
is
one
not a
Some of the
practice,
civil
it
law
is a
countries.
Matter of constitution.
Constitution. It's a matter of constitution. No, my lord, I only sometimes, my lord, abstract questions lead to answers. Suppose in 1950, with Article 245, 246, list 1, 2, and 3, no laws are enacted. There is absolute, my lord, silence, with only pre-constitutional laws being saved under 372. Would your lordships have stepped in or not? In a narrow area to protect certain basic, my lord, rights. Suppose nobody enacts a law. You can't apply Asif Hamid, the service matter, and say that we don't, under
Vishwanath,
309.
We were not lacking in laws. There were too many of them.
Many of
Had
them.
to be
So, my lord,
aligned.
so
That's why
otherwise, my lord, we would
in-
not have had
In
PUDR.
the Laws Act was precisely that.
Precisely that. A reference to
aligning
made to your
with
lordship. My lord, we would not have had, my lord, Vishaka. Vishaka, as your lordship rightly said, was taken in the right spirit, and the Posh Act was enacted, my lord, thereafter.
All right, Mr. Vishwanath,
Yeah.
we conclude now with
Yeah,
your
my lord, I will
submission.
leave my space to others. My lord, will of the people is actually the constitution.
Yeah, it's there out
Both
of the.
B.R. Kapoor, Supreme Court advocates on record, and the NJSC judgment. My lord, workability, I have given your lordship the transgender example. Non-inclusion, under inclusion, I give your lordships the inner court trait test, my lord. And the only other aspect that remains is, my lord, the argument of the learned additional solicitor, Ms. Aishwarya Bhatti, my lord, on the material produced, my lord,
Your item.
Ms. Tara assisting me as the last segment prepared it, and para 63, I'll only read and conclude. The reliance placed by, my lord, National Commission for Protection of Child Rights on articles claiming risks and harms of gender-affirming healthcare is in complete derogation of, my lord, the WPATH guidelines. That is, my lord, World Profession Association for Transgender Health, which are well recognized and followed in India. Reliance on such article furthers the stigma against transgender person and supports the unscientific claims to deny transgender adolescents gender-affirming healthcare, which is a statutory obligation of the state under the Transgender Persons Act. So, my lord, my respectful submission is your lordship will see this note at leisure. There is, my lord, a right. It is required to effectuate the final right, and that, according to me, will be the test for unenumerated rights. If something is ultimately, my lord, the doctrine of implied power test in normal statutes. If a right is required to effectuate my right to life fully, and if by choice I want to marry and bring my association to fruition, and if there are ethical considerations in a marriage also, my lord, between a non-heterosexual, they should also have commitment to one partner. They should also have rights in divorce, my lord. It's not only association. Pauri addresses, my lord, the problem of separation in a homosexual marriage. It has to be dealt with. You can't leave one partner destitute. My lord, High Court of Australia, Justice Michael Kirby, when he was to retire, the Attorney General moved an amendment in the pension bill, my lord. We have got material on that to bring so that his partner is, my lord, covered at that point. That was the, my lord, approach they took in the in the early 2000s. My lord, so the submission is, my lord, that all encompassing, my lord, right. And, my lord, ethical underpinnings also, they should be, my lord, put to the rigors of the ethics of marriage also, my lord. It's not that, my lord, these people, as it was called, could be left to, my lord, stray away from commitments, my lord, in a marriage. So your lordship, my lord, will declare their right to marry, and, my lord, find a positive obligation in them to enact, so that, my lord, they are not deprived of basic rights, my lord, which flow from a marriage, apart from the acceptance, my lord. And, my lord, Cooley says, your lordship says that fundamental rights by very nature are a limitation on the legislative power of the state. You can't leave it to, my lord, the majority, my lord, to decide what they feel, because is ultimately your lordships are the sentinel on the cow. I'm very grateful for this.
Thank you, Mr. Vishwanathan.
My lord,
Mr. Grover? you
my
have-
lord,
Yes, yes.
may I make submissions?
Ms.
My lord,
Luthra.
apologies, my lord. So, my lord, my brief is really principally on the Foreign Marriage Act. And, my lord, the concern was that while we keep talking about the Special Marriage Act, the Foreign Marriage Act is not missed out. The petitioners, this is secular act, the petitioners are validly married. So in their case, I feel that the wrong which is being done to them would be more stark and more glaring than the wrong that will come in case of, and I don't want to say that the Special Marriage Act doesn't need a declaration. I'm saying that I need it and I have a right to it in terms of being a citizen of India, and a citizen of India married abroad who has rights within India, but when I come to India, I become nothing, I become a stranger. Now, one of the arguments, my lord, that I was, the respondents had said, which I found was not apposite, was the argument Mr. Vishwanathan was speaking about the social ethos and about Sri Lanka and Nepal. My lord, the fact is, India's social ethos is far more developed or as developed as those countries. We are in the same subcontinent. So our social ethos is the same. So the argument that we can't be, because of our tradition and our social ethos, we can't be looking at a declaration and at a right to marriage for same-sex couples seems to me not apposite. Second aspect which I thought was that, my lord, ultimately, the Constitution, where did we get our Constitution from? It has taken the best from various constitutions around the world. Now, if it was good enough to take from them, then if we see what other countries are doing with constitutions from which we have borrowed, then surely we can't say now we have to hark back to some tradition which is different from our constitution. So, my lord, this is one aspect. Then the third aspect on this is on, my lord, my note is, rejoinder note is volume 18. But the third aspect is that citizenship, international law, and Committee of Nations are covered under 17(3) of the Foreign Marriage Act. So Committee of Nations takes into account, and I had made that submission earlier, Constitutional Committee also. The time is not just to look at statutory committee, we have to look at Constitutional Committee. Constitutional Committee, as I said, 34 countries and the Yogyakarta principles all come into play. So we are asking for Constitutional Committee. Lord, the next point which I wanted to emphasize was this issue of social morality, which the respondents have talked about. Social morality is to whom and is for whom? The social morality, Navtej has already looked at it and has discussed social morality. Now, constitutional morality is a much higher principle, and social morality to that extent will have to come and in understanding with constitutional morality, which is at a much higher pedestal. Now, my Lord, Dr. Ambedkar talks about it in the Constituent Assembly debates. Then the discussion was made in Keshwanand Bharti, and Grote had discussed it when the Greek historian Grote is discussed when it is said that constitutional morality as a living concept. Your lordships have discussed it in Navtej. So my submission to the court is that constitutional morality has to be given precedence. The concept of a vague, ephemeral societal morality, which is not recognizing or which is not at par with constitutional morality. My Lord, my submission is that that would be misplaced.
Thank you
Then,
so
my
much.
Lord-
Yes.
Yes, sorry, my Lord.
Is that it, Miss?
My Lord, just another 2 minutes, because the reading in part in terms of Gita Hariharan as well as 3 other judgments. I had read Harsova to your lordships, which is and Vijay Manohar versus Saudi, 1987, 2 SCC 278. And my Lord Harsova as well as Gita Hariharan. These 3 judgments I had given your lordships, and reading in has in terms of this South African judgment also, my Lord, if your lordships would recall, there were 4 countries where this the reading in principle with regard to same-sex marriage has been adopted. And I'm only requesting that there is no reason when in India we are at par with those countries, our constitutional rights are at par with them, then why we should not do that. 8 countries, there was the courts actually were the precursor. They asked Parliament to lay down the law. 4 countries, the striking down was done them itself. And the South African judgments, there were 2 judgments. One of them I had cited. The reading in has to be done. Lord, the moment that we say that there is a constitutional right to marry, the moment that we say that right to marry includes a right to have a family, and the moment that we say that sexual orientation cannot be a ground of discrimination, then Article 14, 15, 19, and 21 kick in.
All right. Thank
There
you.
is-
Thanks,
there
Ms.
is-
Lita. Thank you very much. Yes, Mr. Grover. And do you have to add anything over and above what has been said, Mr.
Yes,
Grover?
Lord, mine is slightly different.
What is your formulation, Mr. Grover?
Yeah, Lord, I want to argue that the reason, first of all, my 2 petitions are one on foreign marriage act, other one on interfaith. And this is very important. Both of them tried to register the marriage and they were denied. And in one case, when they tried to register the marriage in India before the registrar, that was denied. And then
Now, we've seen that, but what's the distilled essence of your rejoinder?
Feeling. My Lord, I am trying to ask a question. Why is it that the respondents feel that we should not be allowed to register a marriage? And I want to point to an answer here. Your lordships have decided that actual sexual acts, which were barred by 377, are not criminal anymore by reading down 377. The logical thing would be to also agree to association. Why is it not being agreed to by them? And my submission is that the stigma which the British laws, I'm very careful, British laws 377 and the Criminal Tribes Act attached to the LGBTQI community is persisting today. And the failure to allow marriage allows that stigma, prejudice, and discrimination to continue, which cannot be countenanced by the court. I'll come to the other issue, my lord, about positive obligation. In my respectful submission, apart from 21, as I had argued earlier, 19(1)(c) gives the fundamental right to association, which is realized by a marriage. Why is it that they don't want the marriage to continue? Because in my respectful submission, despite the rhetoric about Nas and Khalsa being historic, they stop at that, which allows this stigma and discrimination to continue. And without fulfilling the right to marriage, the stigma will continue. And the court cannot allow itself to be a party to that and not lend its imprimatur to that. That would be a tragedy. If your lordship would agree with them, then the court would be perpetuating that stigma. Because today what will happen, my lord, after your lordship, if your lordships do not agree with us, we came to the court, we said our rights have to be fulfilled, they have to be realized under the respect, protect, fulfill notions in international law, but your lordship say no. What would that actually result in? It would result in a worse situation for the LGBTQ community. And discrimination and prejudice will continue. As your lordship saw in Dr. Siras's case, a person who's actually gay, a very important issue, if I may. What is it that actually makes them deny this right to the LGBTI community? I say us, my lord. Because they are not actually come to terms with sexuality of the LGBTQI community. You can have sex, the type that you want, but don't bring it in our realm of marriage. That is the real rub of the matter. And that cannot be countenanced by the court. What is different about them? Nothing. Sexual acts are the same. But no, once we legitimize your sexuality, we will be recognizing that in law and we won't allow it. And that is pernicious, my lord. That cannot be countenanced. That's one point. I don't want to elaborate on that, but I made my point. Second point, my lord, apart from the notion under our 14, 16, etc., but the doctrine of classification and arbitrariness, your lordship knows, the court knows that in international law, discrimination is not based on classification. Article 1 of CEDAW, for example, which my lords have used, the Chief Justice has used, it is very relevant. May I just read that only because it is important to look at what is our obligation under international law. Article 1 of CEDAW in the context of women. It says, for the purposes of the present convention, the term discrimination against women shall mean, now please note, any distinction, exclusion, or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on the basis of equality of men and women, of human rights and fundamental freedoms in their political, economic, social, cultural, civil, or any other field. So once your lordship says there is a right to marry, then your lordship have to see whether these restrictions to a particular group denies that freedom. And the answer is clearly yes. So that is an alternative way of looking at it. And your lordship has used, my lord, the Chief Justice in Miss X versus Principal Secretary. That's the, my lord, and the only thing I want to say is that please read Obergefell again, my lord. I know there's a, my lord,
Please read what again?
Obergefell.
Obergefell. Okay. Obergefell.
Now, my lord, I want to just say that I agree with Mr. Singhvi. I don't agree with Mr. Rothgi's solution of affidavit. What I would suggest is what your lordships are looking at as a via media. The special marriage can be a conduit until Parliament enacts, as in Vishaka. Until Parliament enacts, with all its limitations and faults. Now, my lord, I want to read a short poem in the context of what I said. Please appreciate this, my lord. Because it's sexuality which is abhorrent to people. And that thing has to be overcome, that psyche. And my lord, this is a very famous poem by James Kirkup, which led to an obscenity case. And there's a judgment of the Court of Appeal. White House versus Lemon. This is the passionate and blissful crucifixion of same-sex lovers suffer patiently and gladly. They inflict these loving injuries of joy and grace, one upon another, till they die of lust and pain within the horny paradise of another's limbs, with one voice cry to heaven in the last divine release. Then lie long together, peacefully entwined, with hope of resurrection, as we did on that green hill far away. But before we rose again, they came and took him from me. They knew what we had done, but felt no shame or anger. Rather, they were glad for us and blessed us, as would he who loved all men. And after 3 long, lonely days like years, in which I roamed the gardens of my grief, seeking for him, my one friend, who had gone from me, he rose from sleep at dawn and showed himself to me before all others, and took me to him with love that now forever dares to speak its name. Lord, is poignant. I think we should all recognize that our sexualities are no different. Thank you.
Thank you, Mr. Grover. Yes, Ms. Kothari.
Yes. My lords, the argument was made that any kind of My lords, an argument was made that any kind of reading into the SMA would go against the core or the grain of the legislation, using the Gaidan phraseology, and therefore reading in persons cannot be permitted. My lords, I want to submit that the core of the SMA from the parliamentary debates is that it moved away from the sacramental nature of marriage to a contractual nature, and its core was freedom of choice in marriage. And my lords, the parliamentary debates, my lords, may just kindly see my submissions, rejoinder submissions, my lords. Parliamentary debates we have now obtained and they are extracted, which clearly show that the core of the SMA was free choice in marriage, and it did not exclude any person. Even in 1954, of course, at that time it was a man, woman, but this was irrespective of faith and caste and based on constitutional principles. My lords, may just see page 2 of my written rejoinder submissions. In page 2, I will just read
Yes,
out
we've made the point.
yes, 1 or 2 extracts where one of the
We see the point. What is the next point, Ms.
My lords, I will just read out one extract on page 5, that where one of the members in the debate says that we are living under a constitution where certain principles are guaranteed to individuals, liberty of speech, liberty of association, which in my opinion includes the right of every person to choose his or her partner as she desires.
All right. What is the next point, therefore? Yes.
So my
The Sequitur.
Yeah, my lords, is that the debates show that even the SMA was a marriage law for freedom of marriage and choice, and therefore, my lords, reading in as persons would in fact not go against it and would be required for a constitutional framework. And it was never meant to exclude anyone, my lords. And my lords, therefore, reading in, while other judgments have been relied upon, I go on to independent thought. My lords, in independent thought, the exception to rape, 375, in fact, an argument was made that would it be reading up and would the exception to rape for the marriage of a woman, wife aged 15 to extend it to 18, would it be seen as making a new offense? That's what the court asked. Can we make a new offense? And then the court said that we are not making a new offense, but if we don't read 15 as 18, we are in fact failing our constitution duty. And in fact, the court said what Justice Lokur and Justice Deepak Gupta said, that the court said that if we want to make a purposive interpretation, they did not term it reading in or reading up or reading down, but to give a purposive interpretation that protects the rights of the girl or minor girls under the constitution, because the age of marriage was 18, she would lose her right to choice in education and in life. There we have to step in. And in fact, the court said that the court would be failing in its duty if the legislature enacts a law which is violative of the fundamental rights of citizens, is arbitrary and discriminatory. The court would be failing in its duty if it does not either strike down the law or read the law in such a manner that it falls within the four corners of the Constitution. That's all we are asking, my lords, to read it in a way that persons are included, to cover it and make it constitutionally compliant. And my lords, finally, the last point is that, my lords, for trans persons, NALSA specifically guarantees the right to marry. There is a specific requirement that legal recognition is required for enjoying all civil rights by this community, the right to own property, the right to marry. When there is a right to marry, and my lords, when under the Special Marriage Act, transgender persons who have got their gender reassignment can come within man or woman. My lords, all we are saying is that give an interpretation that is purposive to make it all persons, my lords.
Thank you so much, Ms. Guruswamy. And thank you so much, Ms. Kothari. Ms. Guruswamy?
May it please, my lords. My lords,
Yes, Dr. Guruswamy.
My lords, this is my rejoinder submissions, very short, my lords. Serial number 21 in the rejoinder submissions. I've tried to keep it quite brief. I'm responding specifically to the submissions on same-sex parenting, my lords, and adoption rights of same-sex couples by the argued yesterday by the National Commission for the Protection of Child Rights. I don't do so on my personal opinion. I do so on behalf of the Delhi Commission for the Protection of Child Rights. I have also attached, unlike the state, multiple studies with strong methodology, as well as other constitutional court decisions, South Africa, Brazil, multiple other constitutional courts on the right of same-sex couples to adopt, to parent, to be treated as a family, and to be given an equal dignity, and not be reduced to the category of those people. My lords, if I may, my lords, this is serial number 21. Please, my lords. Now, my lords, page 2 of my written submissions is a statement of the Indian Psychiatric Society that consists of 7,000 psychiatrists all over this country. My Lady Justice Kohli has the submissions, my lady.
Looking, I don't see.
This is serial number 21, my lady.
Not there, a few minutes before. You've just mailed it.
Oh, this is a new one.
Your new one.
This is just rejoinder submission, my lord.
But
Just
you already gave one last night and see it.
it's the same rejoinder submission. It's
We'll share it. I have it. with
very well.
Mailed it in the meantime, it's being
My
down.
lord Justice,
I've been compelled to learn all this.
There is one which is
working
volume
well for us.
15. There's a volume 15.
Oh,
no,
Rejoinder.
no, my lord, it's
It's a rejoinder submission.
yesterday a folder of all rejoinder submissions, earlier
But then
yesterday.
you are,
just now,
Oh, I see.
just now.
so the dump continues.
Yeah.
Reading and giving purpose of interpretation to legislation. Yes.
So,
Got it?
Yeah.
so my lord Justice Narasimha has it, my lord? Yes.
Yes, please go on.
Yes. So, my lords, page 2, the Indian Psychiatric Society, which consists of 7,000 psychiatrists or specialists. It's the largest society of mental health professionals in India. The society supported the decriminalization of homosexuality in 2018, and this is what they had to say in April 2023. LGBTQ individuals be treated like all citizens of the country.
It's not here. Wait. Mail it. Oh, abhi kara.
Yes, para 2, my Lord Justice, but that LGBTQ citizens be treated like all citizens of the country, and once a citizen can enjoy all civil rights like education, employment, housing, income, government, military service, access to healthcare, property rights, marriage, adoption, survivorship benefits, to name a few. There is no evidence to indicate that individuals on the LGBTQA spectrum cannot partake any of the above. On the contrary, discrimination which prevents the above leads to mental health issues. And in their recommendation, it is also of utmost importance that the family, community, school, and society in general are sensitized to protect and promote the development of such a child and prevent stigma and discrimination at any cost. This is a child being raised by same-sex parents. Now, my lords, if I may, my lords, there were 4 principal thrusts. So I'm just going to very quickly, I'm acutely aware of the time, my lords. Very quickly, psychological impact of children being brought up in same-sex households, my lords. Now, there are over 50 countries in the world that allow same-sex couples to adopt. So that is more than the number of countries that allow same-sex marriage. Those lists of countries are in the compilation. I'm not going to belabor this here. The most important points is that the big meta studies that have been done over the last 20 years in countries that have allowed same-sex couples to adopt, to have children, the big meta studies by the American Psychological Association, by meta studies in the Netherlands, in Brazil, in South Africa, and all of that is in the note, all make 3 points. 1, that there is no adverse impact on same-sex couples having children and those children. 2, if anything, the lack of protection adversely impacts those children. And 3, that human sexuality develops quite early. So if you do not ensure equality and a protection from discrimination, then young people who are LGBTQ will be, in fact, psychologically impacted. This is what all the studies indicate. They are cited from in the note, and I want to take my lords to page 5, if I may. The American Sociological Review, based on very concrete data, has come to these conclusions. The academic results, this is page 5, my lords, of children raised by same-sex parents from birth outperform children with heterosexual parents by 0.139 standard deviations on academic tests. children raised by same-sex parents from birth are 4.8 percentage points more likely to graduate from high school than children with different sex parents. Support for this hypothesis that has given time-consuming and costly procedures for same-sex couples to obtain children, same-sex parents typically will likely have higher socioeconomic status and therefore better academic outcomes. So I don't want to premise this. I don't want to premise this, and I would hope that in future, when the state comes to argue for or against a case, that the state will locate its findings, its opinions, and form those opinions after talking to communities, after actually relying on studies that do exist for the last 3 decades now in the public domain. Finally, my lords, I want to just take my lords briefly to judgments by other constitutional courts in support of equal parenting rights for same-sex couples. This is page 6 of my written note, my lords. The first case, page 7, para 16. The National Coalition for Gay and Lesbian Equality versus the Minister of Home Affairs. 2000, the year is Constitutional Court of South Africa. My lords, I just want to read these paras because it sums up this conversation here between these two sides that happened 13 years ago in South Africa. It said the South African Constitutional Court says this: from a legal and constitutional point of view, procreative potential is not a defining characteristic of conjugal relationships. Such a view would be deeply demeaning to couples, whether married or not, who for whatever reason are incapable of procreating when they commence such a relationship or become so at any time. It is demeaning to adoptive parents to suggest that their family is any less a family and any less entitled to respect and concern than a family with procreated children. I would even hold it to be demeaning of a couple who voluntarily decide not to have children or sexual relations with one another, this being a decision entirely within their protected sphere of freedom and privacy. In second place, there is no rational connection between the exclusion of same-sex life partners from the benefits of their laws and the governmental interests sought to be achieved thereby, namely the protection of families and the family life of heterosexual spouses. No conceivable way, nor can I think of any.
Dr. Guruswamy,
Yes.
could we have a look at the judgments later?
Yes,
Because
my lord. So
we-
these
we have 15
judgments.
minutes left, so we'll hear the two others.
Very well, my lords. These judgments are all there. There are multiple constitutional courts, and the DCPCR has given a list, my lords, it's a wish list, but of just guidelines on sensitization and education of society and steps that the government can take. I'm deeply obliged.
Thank you, Dr. Guruswamy. Thank you. Now, who will, Mr. Kripal, you'll be arguing.
Acutely aware that I'm on a conveyor belt. And one thing a conveyor belt does when it is go around. So it just reminds me as to why we started with this case in the first place. The idea, Millets, was to try to be equal citizens in this country, to get the same rights that everyone else has as heterosexuals, homosexuals. And Millets, marriage is a vehicle to adopt and obtain that ideal. It is not merely marriage as a social institution that we want. The reason we want marriage is because it is a conglomeration of rights, as was said on the very first date, that the state gives to you. Now, either we can fight for each of those rights individually, or we can get them in one fell swoop by virtue of a declaration by an act. Now, I quite see the problem with the latter, that if we ask for everything, we might end up getting nothing. So the correct thing for us is to ask for a declaration, as my lords have said, in terms of constitutional sense, that you have a fundamental right to marry. Now, Millets, the moment there is a fundamental right to marry, it follows that any two people have a fundamental right to marry, subject to certain state interests being complied with, which include both heterosexual and a non-heterosexual couple. Thus far, no problem. This declaration can come. But when a declaration must have a certain consequence in as much as it must ameliorate or identify or meet with the problems with which we came to the court in the first place. Because the declaration in a vacuum, saying that the Supreme Court hereby declares that any two people have a right to get married, must in some way be formalized into the practical impact of any two people's day-to-day life. So that when two people say that, look, the Supreme Court has said, I have a right to get married to my partner and therefore give him a visa or open a bank account or get an insurance document, there must be some formal aspect or carrying out in the nitty-gritty details, howsoever little of that larger constitutional declaration of precept. What I would submit, Millets, is Section 4 of the Special Marriage Act gives just such a precept. My lords will recognize a right under Section 4 of the Special Marriage Act, in which case not much violence is done to the act of to Section 4. The problem arises in terms of unworkability once that declaration has been given to all the other rights. And there, Millets, I would say, hold your hands. Because it becomes, SMA will not become unworkable for the heterosexual community. It carries on working, it does. There are aspects of the SMA which may become unworkable. But Millets, I would just remind my lords that slightly unworkable is better than nothing. And nothing is what we have just now. So if we get a declaration under Section 4, Millets, it means a lot to any member of a community to go and tell their parents that, look, I'm getting married. It means a lot to any member of the community to say that the Supreme Court of India has permitted me and I have officially gotten married. It is an official document, Millets, which, in my lord, the Chief Justice's formulation of the 5 concepts of what include marriage, which is the ability to exclude, the right to cohabitation, the right to procreation. It is very important to have societal recognition of that relationship. And two people will not get societal recognition of their relationship by an abstruse declaration of the law for any two people by the Supreme Court. It must be carried into practice in some manner. And Millets, therefore, Section 4, a simpliciter declaration that you fall within Section 4 will suffice. To the extent, and my lord will see Section 4, my lord just call us in, there is actually no violence to the language of the Act that we will have to do substantially. Notwithstanding anything contained in any law for the time being in force relating to the solemnization of marriages, a marriage between any two persons, no problem, may be solemnized under this Act if at the time of the marriage, the following conditions are fulfilled, namely, neither party has a spouse living, neither party is incapable of giving valid consent to it in consequence of unsoundness of mind, though capable of giving valid consent, has been suffering from mental disorder, has been subject to recurring. The only problems are C and potentially D. C, that the male has completed the age of 21 years and the female the age of 18 years, and the parties are not within the degrees of prohibited relationships. These are the only two sections that will have to be tweaked. If there's a problem that stems from 21A, that is left to a future wisdom. At best, what will happen? That you will not get certain rights. We are not getting those rights today in any case. So what is the worry? How is it an unworkability argument? This is an argument saying that you cannot get everything, so I will give you nothing. That argument will not suffice. The other alternative, Millets, as can be suggested, is Section 15 and 16. There, Millets, these problems of age as well as degree of prohibited relationships don't come in. My lord will see Section 15. Because a marriage can be solemnized under the chapter 1 of the SMA, it can also be registered under Chapter 3, registration of marriages celebrated in other forms. Any marriage celebrated, whether before or under the commencement of this Act, other than a marriage solemnized under the SMA 72 or under this Act, may be registered. So we get married anywhere else, it can be registered under this chapter by a marriage officer in the territories to which this Act extends if the following conditions are fulfilled. The ceremony of marriage has been performed between the parties and they have been living together as husband and wife ever since. Just stop here for a moment. A ceremony of marriage has not been defined as to what it is. It could be anything. I could go and, either in Jewish tradition or Parsi tradition, because there are different forms. The Act does not say what is a ceremony of marriage. It can be anything. I can go and tell before a priest of my choice or anyone saying, I hereby take you as my spouse. That would fall within the definition of ceremony of marriage because there is no description here in the Act. My choice of ceremony will not run afoul of the Act. And have been living together as husband and wife. This, Millets, can be tweaked to the extent of spouse. And the words are living together as husband and wife implies that you are in a cohabiting relationship. That is the implication of this particular subsection. But more importantly, let's see clause B has neither party has at the time of registration more than one spouse living. C, neither party is an idiot or a lunatic. This language really needs to be updated. D, the parties have completed age of 21 years at the time of registration. So there, this problem of 18 and 21 does not apply because both parties have to be 21. So whoever it may be. E, and again, Millets, parties are not within the degrees of prohibited relationship. So this also is gender neutral. it will apply to a man and a woman. There is no problem whatsoever in a section 15 argument, provided that in the case of marriage celebrated before the commencement, condition shall be subject to any law, custom, or usage having the force of law governing each of them, which permits a marriage between the two. Since it doesn't, this will not apply to us because we are getting married in a ceremony.
Degree of prohibited relationship is unprohibited relationship opposite. Yeah.
The problem 16 is a simpliciter recognition of once you fulfill the conditions in 15, 16 will be registered upon receipt of an application signed by both the parties to the marriage for the registration of the marriage, again gender neutral. Under this chapter, marriage officer shall give public notice thereof in such manner as may be prescribed. And the procedure will follow. So well as this is a gender neutral way of allowing marriage to be recognized. And the third is a submission that Mr. Rodhi gave, which that you allow registration of marriage under section 18F of the Registration Act. Because the only two problems I see with that, the only problem I see with that, and I would commend either section 4 or section 15 route, because both can be followed without much tinkering. Because every other unworkability argument also affects an introduction of Article 31D in our Constitution. Because future parliaments will now become very clever and say, why should I bother with amending the Constitution to save a legislation? I will just make it so complicated that striking it down becomes unworkable, and it therefore has a constitutional protection. For instance, whether the reservation is to be given, I will give 2% reservations to 30 scheduled castes and not to the 31st. And say, well, if you struck it down, there's no reservation for anyone. Out it goes. Well, this is just one example of a potentially unworkable act being struck down, being rendered immune from judicial review on the ground of unworkability. There is reason why no case has been cited before my lords where the word unworkability has been used as a defense to constitutional examination, because it is not a valid constitutional defense. It is a purely legislative act which they're seeking now somehow to get over our fundamental rights by legislative device. That's something that cannot be permitted. That's all I have to say.
Thank you, Mr.
And let's just, we have an affidavit of Mr. Rodhi wanted to circulate as to what kind of affidavit can be given in case the registration under section 18F of the Registration Act is to be done. It's in volume 24 of our submissions. Obliged, my lord.
Yes, Ms. Grover.
Please, my lord. My lord, since my petitioners fall into two different groups, my prayers also, one relates to Special Marriage Act, which has been extensively argued. I would only add one strand to that for my lord's consideration, which is the ratio of Dharani sugars. That statutes must be treated as always speaking. My lord, the Chief Justice has applied that very ratio in Miss X versus Principal Secretary Health to read the impugned rules under the MTP Act to recognize a single woman's right to abortion where it related specifically to marital status. So whether that ratio can be deployed here to recognize LGBT couples' marriage within Special Marriage Act. My lords, the other prayers in my petition, which relate to those who do not wish to necessarily be married within the legal regime, have not been countered or opposed either in the counter affidavits filed or in the oral submissions, which are three prayers. One, to recognize, give constitutional recognition to my right to form a chosen family, which has already found recognition in the atypical family that my lords have elucidated upon. Then, which are can also be non-conjugal in intimacies that persons may have who are queer and trans persons. The second is the right to nominate beyond guardian, blood relative, or family member and assign various rights. And again, a constitutional recognition to that. And the third, which Mr. Ramachandran has already mentioned, a protocol of protection from violence, both building upon Shakti Vahini and the Madras High Court order, but ensuring that that provides agency and autonomy to those who are being safeguarded and protected. My lords, just one last bit in terms of non-workability. Again, I think Mr. Ramachandran has mentioned, because there was a lot of concern expressed by the respondents, the experience of NALSA and the Transgender Act. different high courts, whether on issues of domestic violence, sexual violence, reservations, have made it workable, and that is an ongoing process. I would only reiterate what has been said just now again, to say that these are vulnerable, high-risk populations, particularly when there are further marginalizations of class, caste, etc. Non-recognition and non-granting of certain rights will certainly increase the discrimination and violence. So it is an Article 21 issue also. I'm very grateful.
Thank you, Ms. Prabhu.
My lords,
Yes, Nandi.
my lords have my submissions in
Yes.
rejoinder dated 10th May. It's in the
Yes.
common compilation that was sent, I think, yesterday morning, my lords. My lord, there are three propositions. One, happily, has been dealt with by Mr. Kirpal, that Chapter 3 of the Special Marriage Act, Sections 15 to 18, require the registration of marriages celebrated in other forms, and that these are gender neutral and may come to our aid without any words whatsoever being read into the Special Marriage Act, my lords. My lords, Mr. Kirpal has very well taken you through the section, so I won't do that. I will only add that when the section says as husband and wife should have been living together since the celebration, Black's Law Dictionary, the Oxford English Dictionary, it all comes to our aid, and it says that as means like, similar to, of the same kind, in the same manner. My second proposition, my lords, is that to the extent the phrase forms of marriage under Section 15, Chapter 3, presupposes extant validity under law, the common law may be brought to bear to develop the contours of the right through stare decisis. My lords, it would be remiss of me to mention, despite the time, that Professor Tarunab Khaitan and Professor Mitra Sharafi have helped us with these submissions under a lot of pressure of time. The life of the law, my lords, as Oliver Wendell Holmes says, has not been knowledge, it has been experience. So therefore, the fact that we have been here before is relevant. That Parsi marriage laws, and I'm reading from page 3, my lords, that Parsi marriage laws were a creature of common law prior to their codification. There is no religious source. Not that there was never any religious source, but at the time that they were looking at it, there was no religious source. During the emigration from Persia, their books were lost, creating a vacuum in law. And we have cited Dr. Sharafi's book, which has looked into this, and her dissertation was specifically on these issues. Marriage and divorce between Parsis, therefore, was regulated by English ecclesiastical or Christian law. Default for Zoroastrians living in presidency towns in Kasarchi versus Piroz Boy in the Privy Council, the appellant husband objected to this. He said, look, Christian laws can't apply to me, surely. He said that the jurisdiction of the court to decide the matrimonial dispute between a Parsi couple and to apply Christian law.
In rejoinder, you will have to specifically take up the points which they have argued and then tell us.
My lords, the point is only
the
this.
points that they have taken.
Yes, my lords. My lords, the point that they have taken is that they said that we are, essentially they said that we are in a vacuum. That ecclesiastical jurisdiction doesn't apply, but on the civil side, the civil courts can develop it.
Literally. The Parsis' migration predated the advent of the Europeans. So they had regulated within their own institutions, marriage, the solemnization, separation, whatever else. The advent of the British only lent a forum and perhaps a codification.
My lords, I'm so grateful. My lords, what the judgment says and what the commentators at the time were divided on was what they should do when there was no ecclesiastical law. So the solution they came to is that they said that let the Supreme Court of Bombay on its civil side develop it on a case-by-case basis. And so they said, and I've reproduced it all here. I also have the references, my lords. What they said was that we understand that ecclesiastical law should not apply, but we should much regret if there were no court and no law whereby a remedy could be administered to the evils which must be incidental to married life amongst them. We do not pretend to know what may be the duties and obligations attending upon the matrimonial union between the Parsis, nor what the remedies may exist for the violation of them. But we conceive that there must be some laws or some customs having the effect of laws which apply to the married state of persons of this description. It may be that such laws and customs do not afford what we should deem as between Christians an adequate relief. And so then they go on to say, such remedies we conceive that the Supreme Court on the civil side might administer, or at least remedies at nearly approaching to them as circumstances would allow. Proceedings might be conducted on the civil side with such adaptation to the circumstances of the case as justice might require, though on the ecclesiastical side, such modification would be wholly irreconcilable with their particular situation. My lords, what we are saying is that a declaration would go a long way towards recognizing my rights. But my lords, what I am saying also is our plea is to bring the Constitution to my home as well. Do not let my humanity, my lords, be reduced to a separated singular identity. My lords, allow me to consecrate my love. I'm so grateful, my lords.
Please, my lord. I'll just put 3 points before my lords. The first is that my lords are contemplating whether the Constitution recognizes a fundamental right to marry. That, my lords have indicated, perhaps may be found across the rights that are enumerated in Part 3. And, my lord, that the right to marry would have certain contents which are already recognized under law through various statutes. My submission in this regard would be that it fell from your lordships on the previous date that the contents would include, my lords, for example, the right to found a family, the right to procreation, and so on and so forth. The first content I would submit, my lords, of this right to marry must be the status of being married itself. This is, my lord, distinct from the rights and obligations that flow from a marriage. The status of being married, my lord, the recognition of the relationship itself confers a couple with dignity. This is, my lord, dehors any rights and obligations that flow from the marriage. And therefore, my submission, my lords, that the first right, my lord, that is recognized, the first content of this right to marriage, my lord, would be the recognition of the marriage itself and the status of being married.
Yes.
Please, my lord. That's my first submission. The second submission, my lord, is this, that it was indicated to your lordships yesterday that if my lords were to give such a declaration, it would bind future parliaments. It would bind future courts. And that is the nature, my lords, of Article 141. It is inherent, my lord, to the obligations of this, the constitutional obligations of this court. In Nalsa, my lord, the formulation which, and Nalsa, my lord, as the nodal judgment when it comes to questions of gender identity and sexual orientation, the formulation that this court gave was first to indicate, my lords, the content of Part 3 rights when it came to transgender persons, and then, my lord, to actualize those rights through specific directions that your lordships gave to central and state governments. So, my lords, I'm completely with my friends on this side that any declaration that your lordships give must be actualized through an enunciation of the Special Marriage Act. But in addition, my lords may see the declaration that your lordships have given in Nalsa, and I believe my note may have reached your lordships too late to be uploaded, so I won't trouble your lordships with it. But, my lord, in para 135, in conclusion in Nalsa, your lordships gave detailed directions. These, my lord, included directions to recognize transgender persons as a third gender, directions to central and state governments to recognize transgender persons in their self-declared gender identity. And all these directions, my lord, were traceable to the enrichment of Part 3 rights that your lordships recognized. I won't break the convention of this court, my lord, by handing over physical copies of my note. I'll just continue. But The third, my lord, was a very valuable direction to extend Article 16 for protections to transgender persons. So transgender persons were found to be a historically backward class. And this, my lord, perhaps may be the first time that the concept of historical backwardness was expanded to include a new community, what has now been done with EWS, my lords. The next direction to central and state governments was to address health issues of transgender persons. For instance, my lord, directions to NACO to set up sero-surveillance centers, or, my lord, to provide separate toilets. So here the direction, my lord, aside from the declaration of law, the direction, my lord, was traceable to the right to health under Article 21. There was also a direction, my lord, to the central and state governments to address the problems of fear, shame, gender dysphoria, etc. So therefore, my lord, to bring about a change in social values regarding transgender persons. So this is the extent, my lord, of the directions which were given in NALSA, along with the declarations. And finally, my lord, direction to the central and state governments to frame social welfare schemes, which are also traceable to Part 3 rights. Now, what has been the effect of the directions coupled with the declaration that fell from my lords in NALSA? Did Parliament stop debating the issue, or various state legislatures, as has been indicated to my lords? Did social debate on these issues stop? Not at all. What happens, my lord, is we now have many states, including the state of Madhya Pradesh, for example, which have brought about policies for the welfare of transgender persons. And my lord, my friend Mr. Dwivedi appeared on behalf of the state of Madhya Pradesh. But like me, my lord, he is from the great state, may I say, of Uttar Pradesh. And my lord may see what the state of Uttar Pradesh did, following my lord's directions in NALSA. The 7th State Law Commission, my lord, in Uttar Pradesh, entirely relying on my lord's directions in NALSA, finds that they have been directed to improve the conditions of transgender persons and specifically take up the issue, my lord, of laws of inheritance. So what do they say, my lord? The Hindu Succession Act as well as the Indian Succession Act are central legislations, and although the state government has power to amend these legislations with the concurrence of the central government, this has a long procedure. Therefore, this commission has confined its study to the right of succession in agricultural property as well as the grant of lease regarding Abadi lands in Uttar Pradesh. And what, my lord, has the great state of Uttar Pradesh, for which I'm a proud citizen, my lord, of Allahabad, has it held? They amend the Uttar Pradesh Revenue Code in 2020, and what do they introduce? The family in relation to a tenure holder means himself or herself and his wife or her husband or third gender spouse. This is the current state of the law in UP, my lord. As the case may be, other than a judicially separated wife or husband or third gender spouse, minor sons, minor daughters, other than married daughters, and third gender minor issue. So not only, my lords, following your lordship's declaration and directions in NALSA, not only do state legislatures now recognize third gender children as successors to the estate, they also recognize the possibility of third gender marriage, of marriage of third gender persons, as the statute calls it, and in fact, even situations where there may be a judicial separation of such persons. And thereafter, my lord, they are incorporated into the degrees of succession as the RAND revenue codes imagine, my lord. So, my lord, my submission is that your lordships open the door. Your lordships tell us as a country where the law stands and where our constitutional values stand. And then, my lords, a social debate happens, a legislative debate happens, and my lords, we as a country, we adhere to the constitution. We bring ourselves, we rise, my lord, to the level of the constitution. The last submission I'll make is this. Your lordships have in effect been told that because there's a vast problem of statutory interpretation before my lords, your lordships should not touch the constitutional issue. That your lordships will be so troubled by a question of statutory interpretation, however frequently it may arise, my lord, and however many statutes it may arise. But if I may just submit to your lordships, if my lords take yourselves back, perhaps 15 years or maybe even more, when my lord sat as single judges in the high courts. And perhaps, my lord, a young Justice Narasimha then appears before my lords. And my lords, these issues come up, my lords, in MAT FCs, in MAT appeals, in FAOs. And they are questions, my lords, then of statutory interpretation. They arise, my lord, in individual cases relating to individuals who come before my lords in many combinations, as my Lord Justice Bhatt has put to us throughout the course of these proceedings. My lords, look at the facts. And my lords, this is why, my lords, we are not running away from a question of statutory interpretation. We are not saying that these questions are insurmountable. It was asked in this court, my lord, who will be the father or who will be the mother? My lords will look at the statute, as my lords would have done 15, 18 years ago. Look to the statute, look to the law and the declarations laid down by the Honorable Supreme Court, and will find solutions for the persons who come before them. Because, my lord, Parliament can choose when it decides to address an issue. Parliament can choose, there may be a social problem, and Parliament can turn a blind eye. But, my lords, your lordships, the high courts, and the courts below, the family courts, the civil courts, they do not have that luxury, my lords. When persons raise a list before your lordships, when they come with a cause of action, the courts have to address those questions, and they have already been so doing. There are cases going back to the 1990s, my lord, where transgender persons have come raising questions, my lord, do we fall under the HSA, for example? And the courts, in one occasion, say, no, your customary law applies to you. In another case, my lord, again involving transgender persons, the courts say, no, Muslim law applies to you. So, my lords, our only submission is this. Today, what is the reference before your lordships? Your lordships limited the reference to the Special Marriage Act. We are not going beyond that act, whether it is in questions of the Hindu Marriage Act, my lord, or on questions of other statutes. Because that was not the nature of the reference. But it's not, my lord, that these questions are in any way unanswerable. So let me end, my lord, with this. It fell from my Lord Justice Bhatt, for example, that suppose there are two Hindu women who are a couple, and one of them passes intestate. So let's take the case, my lord, of a female Hindu passing intestate. How would my lords then interpret the HSA? And my lord, it's been argued on this side that some have argued that Section 21A ought not to apply. Some have argued, and I have argued, that 21A ought to apply. My note deals with that in detail. I won't trouble your lordship with it anymore. But let's suppose, my lord, that we come to this point that there's a question of whether the Hindu Succession Act applies, my lord, to, my lord, a female Hindu who dies intestate. What does 15 say, my lord? The property of a female Hindu dying intestate devolves according to rules set out in Section 16. Firstly, upon sons and daughters, including the children of any predeceased son or daughter. Secondly, upon the heirs of the husband. Thirdly, upon the father and mother. Fourthly, so and so. So what happens here, my lord? And I'll just end with this. My lords will deal with the question of a female Hindu, my lord, who has a spouse, and therefore there will be a question at that stage of does this act now envisage that the spouse of a female Hindu is covered here, but her husband, but the children, my lord, will be covered. And the issue, my lord, as to how these statutes will be interpreted, what will be the interpretation, my lord, is one to be left to those courts to decide. I'm highly obliged, my lord.
Thank you.
I'm highly obliged.
So we'll conclude here. We'll reserve judgment. Thank you, everyone.
Grateful, Lord, it was
Immensely grateful.
lightning,
Yeah.
Lord.
And what a pleasure it is to see all five of your lordships today sitting here in court. Much obliged.
Grateful, Milord.
Thank you.
Thank you, everyone.
Thank you.